Supplementary list item number 1.
Item 1 may plus.
ଆପଣଙ୍କର ଆଗକୁ ଆସନ୍ତୁ ଆପଣଙ୍କର ଯୋଉ ନୋଟାରୀ ପବ୍ଲିକ ଆପଏଣ୍ଟମେଣ୍ଟ ହେଲା ପରେ ଆପଣଙ୍କୁ କିଛି ଟ୍ରେନିଂ ଦିଆଯାଏ? ଏପର୍ଯ୍ୟନ୍ତ କିଛି ଟ୍ରେନିଂ ଦିଆଯାଇନି। ତ ଆପଣଙ୍କୁ କଣ କରିବା ଉଚିତ କଣ କରିବା ନୁହେଁ ଆଇନ ଅନୁଯାୟୀ କିଛି ଇଏ ନାହିଁ। ତ ଆପଣଙ୍କର ଯଦି କୌଣସି କାର୍ଯ୍ୟ ଯଦି ଡେଭିଏସନ ହୁଏ ଯାହା ଯାହା କରିବା କଥା ସେଗୁଡାକ ଆପଣ ତା ବାହାରକୁ ଯାଇ କରନ୍ତି ତାହେଲେ କଣ ଆକ୍ସନ ନବାର କଣ ପ୍ରୋଭିଜନ ଅଛି ନୋଟାରୀ ଆକ୍ଟଟା ଦେଖି?
Apology membership license will be considered. Apology membership, pardon membership. It is one membership that I am appearing to the petitioner membership. The victim is now not interested with live with the present petitioner membership.
Please take your seat. Different matter. Don't be too smart. We are on a different footing. ये लाइब्रेरी को तुरंत बनेगी ना maybe yes. Proceedings of professional artists based on which he entered the file with disqualification procedure. What fees you are required to pay when you are appointed as notary or it is renewed or no fees?
Yes, sir.
केते टका प्रथम जेतला आपण अपॉइंटमेंट ले केबे इतले को ईयर रे
2012 सर।
हां
12
2012
हाँ।
केमती आपण अपॉइंटमेंट ले की आपण
इंटरव्यू दे लॉ डिपार्टमेंट
हां
लॉ डिपार्टमेंट
ओडिशा सारा तो 40,000 ऊपर एडवोकेट अछन आपण कोन पई करा गला
हम सर फॉर्म पकले 10 इयर्स प्रैक्टिस पर
हां
10 इयर्स प्रैक्टिस पर एलिजिबल हले अप्लाई करिया पे
का को अप्लाई करी
लॉ डिपार्टमेंट
गोटे फॉर्म अछि
आगे
तापर कोन हुए
तापर सर हमको इंटरव्यू पे डाकन इंटरव्यू पे डाकन इंटरव्यू देला सिलेक्शन
आपण केस रे इंटरव्यू हेइथिला
ଆଜ୍ଞା ସାର୍
କୋଉଠି ହେଇଥିଲା?
ଲ ଡିପାର୍ଟମେଣ୍ଟ।
ତାପରେ ନୋଟିଫିକେସନ ବାହାରିଲା,
ସାର୍
ଆପଣଙ୍କୁ ମଧ୍ୟ କମ୍ୟୁନିକେସନ ହେଇଥିବ ଅର୍ଡରଟା।
ସାର୍
ତ ଆପଣଙ୍କର ବାଲେଶ୍ୱରର କେତେ ଜଣ ଆପ୍ଲାଏ କରିଥିଲେ, କେତେ ଜଣଙ୍କୁ ମିଳିଲା?
ଆମେ ସାର୍ ସିମୁଳିଆ ବ୍ଲକ ପାଇଁ ଆପ୍ଲାଏ କରିଥିଲୁ।
ସିମୁଳିଆ ବ୍ଲକ ପାଇଁ
ପୋଷ୍ଟ ନାହିଁ
ଆପଣ କେତେ ଜଣ ଆପ୍ଲାଏ କରିଥିଲେ?
ଜଣେ
ସିମୁଳିଆ
ସାର୍।
ଏକୁଟିଆ ଆପଣ ଆପ୍ଲାଏ କରିଥିଲେ? तो ଆପଣ ଯୋଉ application ଦେଇଥିଲେ, is there any requirement to give any deposit any fees for that?
ସାର୍
What is the fees?
ମନେ ନାହିଁ ସାର୍।
अच्छा,
requisite fees କେତେ ଦେଇଥିଲେ application ବେଳେ?
ମନେ ନାହିଁ।
so that would be issued for 5 years.
हाँ।
ये जो प्रथम सर्टिफिकेट
Sir,
5
sir,
years
sir.
ଥିଲା। ସେ 5 years पूरीबा पूर्वरु आपनको आउ थरे रिन्यूअल ପାଇଁ आउ थरे एप्लीकेशन देबाक पड़े ना कोन?
Sir.
तापरे आपण ଦେଇଥିଲେ,
हाँ सर
सेठी कोन हला आपनको?
रिक्वेस्ट अमाउंट देला ପରେ ଫେରି ନହେଲା।
नहीं सेते बेला au किछि फीस गरिया
हाँ
फीस डिपॉजिट हुए
सर
आपण के ଦେଇଥିଲେ सेकंड टाइम?
1200 କେତେ ମନେ ପଡୁନି ସାର୍।
अच्छा, then it was extended.
ଚାଲାଣ
so 12/5 प्रथम हेतला 12/5 17
Sir.
तापरे हेला 17 रु 22 हेतिबो।
हाँ।
तापरे
ତାପରେ ଡିପ୍ଲିକେଟ
पुणी 5 वर्ष एक्सटेंशन।
ସାର୍
वर्तमान आपनकर 2023 पर्यंत अछि।
ସାର୍
हां
ସାର୍
डॉक्यूमेंट दीचन
Second
Okay.
affidavit.
सेकंड एफिडेविट सी then what happened? चलो 5 years government of so on receipt of annual publication of the list of notaries, seal of notary. ଆପଣଙ୍କର ଯୋଉ seal ଆପଣ ଯୋଉ ୟୁଜ କରୁଛନ୍ତି ସେଗୁଡାକ ଆପଣ ନିଜେ ତିଆରି କରିଛନ୍ତି ନା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ତରଫରୁ ଇସ୍ୟୁ ହେଇଛି?
ସେ ନିଜେ ତିଆରି କରେ।
ହାଁ
ନିଜେ ତିଆରି କରେ।
କଣ seal ରେ ରହିବ ବୋଲି କେମିତି କୋड ପାଇଲେ? seal ରେ କଣ ସବୁ ରହିବ?
ଆମ ସିନିୟର ନୋଟାରୀ ଭାଇ ଅଛନ୍ତି ତାଙ୍କୁ ପଚାରି କଲି।
ସେ ଅନୁଯାୟୀ ଆପଣ କରିଦେଲେ ମାନେ
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗାଇଡଲାଇନ ର କିଛି ନାହିଁ।
ଗଭର୍ଣ୍ଣମେଣ୍ଟ କିଛି ଗାଇଡଲାଇନ ନାହିଁ।
ସେଇ ନାହିଁ।
ओके देन ଆସିଲା ଆପଣଙ୍କର functions of notary section 8 ବେଳେବେଳେ କ୍ଲର୍କ ଏତେ ଗୁଡାକ ଆଫିଡେଭିଟ ଧରିକି ପଳେଇ ଆସନ୍ତି, ଡିପୋନେଣ୍ଟ ନଥାନ୍ତି, ଗୋଟେ ଆଫିଡେଭିଟ କରନ୍ତି ନା ନାଇଁ?
ନା
ହାଁ
ନା
ସବୁ ଗୁଡାକ ଆପଣଙ୍କ ଡିପୋନେଣ୍ଟ ଆପଣଙ୍କ ପାଖକୁ ଆସେ?
ସାର୍
ହାଁ
ସାର୍
ତାକୁ କେମିତି ଭେରିଫାଏ କରନ୍ତି ଏଇ ଯୋଉ ଲୋକ ଆଫିଡେଭିଟ କଲା ଇଏ?
ଆଡଭୋକେଟ ସାର୍
ହାଁ
ଆଡଭୋକେଟ ଥାନ୍ତି ସାର୍।
ଆଡଭୋକେଟ ଆଇଡେଣ୍ଟିଫାଏ କରଲା ଆପଣ କରିଦିଅନ୍ତି,
Sir.
ଆଉ କିଛି ପ୍ରୋସିଡିଓର ନାହିଁ?
ନା ସାର୍
ସେ ଲୋକଟା ସେଇ ବେଲି ଏକ୍ସ ଆସି କହିଲା ଯେ ଏଇ ଯୋଉ ଲୋକଟା ଆଫିଡେଭିଟ କରୁଛି
ଆଧାର କାର୍ଡ
ହାଁ
ଆଧାର କାର୍ଡ ସାର୍
ଭେରିଫାଏ କରୁଛନ୍ତି,
ସାର୍
ତାହେଲେ କଣ ଗୋଟେ ଲୋକ ଯୋଉ ସତ୍ୟପାଠ କରିବ ଆପଣଙ୍କ ପାଖରେ
ସାର୍
ଆପଣ କଣ କଣ ଭେରିଫାଏ କରିକିନି ସତ୍ୟପାଠ କରାଇବେ ଏମିତି କିଛି ଗାଇଡଲାଇନ ଅଛି?
ନା ସାର୍
notaries rules देखिए हाँ किस समय हेलाणी कौन ता जो लिखा हुआ
serial number, name, address, date, signature, remarks.
मन करो आज माने 10 तारीख रे आपण पाखु 20 एफिडेविट आसिला हला से 20 जो माने डिपोनेंट आसिकिनी जो एफिडेविट कले तांकर रेकॉर्ड रे मेंटेन हुए ए माने ई हां
Record sir name maintain हुआ पर signature था
हां
sir.
सब गुडा को सिग्नेचर आपनकर रजिस्टर रु डाकेले अबिया देखा जीवो जे सब डिपोनेंट माने से रजिस्टर साइन करिसेंती
Sir करंती
हां
करंती sir.
डिपोनेंट करो बिना उपस्थिति रे सत्यपाठ करैबाटा ठीक की
ना
तो जदि आसिले तार प्रमाण स्वरूप रहिला उची register would indicate that yes that person has in fact come and who time रे सी आसिला एवं एफिडेविट कला ए सब रजिस्टर रे मेंटेन हेकिन तार सिग्नेचर रहिबा दरकार
sir
हना नहीं
sir.
आपण जो नोटारी जो करछन्ती ता देरे टाइम पकाउछन्ती
Time sir पड़े नहीं sir.
हां
Date sir पड़े
आपण टाइम पकिया दरकार नहीं
ना sir दरकार sir पक्के हुए नहीं sir.
हां आउ रजिस्टर रे दस्तखत दरकार ना नहीं
Sir
रजिस्टर दस्तखत दरकार नहीं चंदी सब
हाँ sir
डिपोनेंट
हाँ sir.
देखिए ଦେଖିବା ଏଠାରୁ କଣ ସେ କରିବେ। ଏଇ 1 ନମ୍ବର ବାଥରୁମ ଏଇଟା କଣ ଯାଉଛି? Restriction ଟା ପଡ। Annexure declaration. Inquiry into the allegation of professional or any misconduct. Encouragement kind of the person come to know will be Mr. Das, after going through this notary act and notary rules, we find that detailed procedure has been prescribed as to how the appointment is to be made and what are their duties and responsibilities and how action can be taken for any professional misconduct, how the seal is to be used. He said that there is nothing but it is
Everything is there.
everything is there. So question is that why we are asking, he asked that there is no training program. It requires a training program to all the notaries. Now in virtual mode, it can be given that what to do, what not to do. So that
there should be a training program. Whereas the new notaries, those who are
right, not only new, but all the notaries should participate, and their names should be that whosoever are participating, that should be there on record that these persons are either in a particular area, such type of program, or in the virtual mode or throughout the Odisha. It is to be given.
Organized.
Right. And specific instruction is to be giving that like this marriage, etc., that is not to be performed. And if somebody, in spite of that training, if he deviates from that, then there is a procedure that how the proceeding can be initiated. So, but they are not aware that what is to be done, because so many decisions have come by the Honorable Supreme Court, by this court, not only on this marriage issue, but also on other issues.
On other issues also. So far, the general power of attorney is concerned regarding the transfer.
That is to be, first of all, your agency, government agency should verify those decisions. Okay, what instruction have come from time to time. Okay, it is to be then after collecting that, a training program should be given, and all those decisions are to be told to all those notaries. So that will we are passing that.
Yes, ma'am.
Okay.
Yes, ma'am.
Whatever decisions have come under notaries are
like the judicial officer getting the trainings, my lord.
Right.
So like that,
hand on training
yes,
organize so type of training
nowadays also the public prosecutors, FPP, and also going on training program. That's like that one orientation program, and
because maybe that these decisions have come, but he said that I was not aware. Maybe it is maybe true also.
Because those who are staying in the remote areas, my lord.
Number of decisions of this court, Supreme Court has there. We have also mentioned some of them in the past already.
Earlier also, my lord. Our High Court also.
Yes. So, in spite of that, and these are also sometimes it is reported also in Japan.
Yes, reported.
But they are not aware about it. So, all right, take down. This writ petition in the nature of habeas corpus has been filed by Parthasarathi Das, for a direction to cause production of his wife, bracketed like to opposite party number 6, before this court, and to give or in the jima of the petitioner. So, para. In the writ petition, averment has been taken that the petitioner and the opposite party being major gave their marriage declaration on 19/4/2023 before the notary public in declaring that they solemnized their marriage on 19/4/2023, and since then they are treating each other as husband and wife. It is further stated in the writ petition that on 9/5/2023 at about 8:40 a.m., the opposite parties number 7 and 8, namely Jalendra Jena and Ganapati Rana, in making false promise before the petitioner, took away the opposite party number 6 to their custody and made illegal confinement of her. It is further stated in the writ petition that both the petitioner and the opposite party number 6 belong to same Gram Panchayat, and they were also prosecuting their studies in the same school, and there was love affair between the two, and the petitioner acquired qualification of +2 diploma mechanical at Government ITI Balasore, and did his apprenticeship training under Suzuki Motors Private Limited, Gujarat. And opposite party number 6 also acquired educational qualification of +2 science and completed +3 and then appeared for BED. It is stated in the writ petition that the date of birth of opposite party number 6 was 5/6/1997, and the petitioner's date of birth is 19/4/1997. In support of such averment, copy of the HSC certificate and Aadhaar card have been annexed to the writ petition. It is stated that the opposite party number six, 7, and 8 oppose the relationship between the
7 and 8, your lord.
7 and 8. 6. Acha. Say 7 and 8 oppose the relationship, and for which the petitioner and opposite party number 6, after attaining permissible age of marriage, collected e-stamp on 19/4/2023 and solemnized their marriage, executing an affidavit of declaration of marriage before notary public. The declaration of marriage dated 19/4/2023 has also been annexed to the writ petition as Annexure 2 series. It is further stated that after solemnization of marriage, petitioner and the opposite party number 6 were leading a happy conjugal life. And neither the opposite party number 7 nor the opposite party number 8, who are related to the opposite party number 6, had any complaint against the conjugal life. It is further stated that when the petitioner and the opposite party number 6 were staying in Darsi district in Andhra Pradesh on 9/5/2023 at about 8:40 a.m., the father, mother, brother, and maternal uncle of the opposite party number 6 came there and convinced the petitioner and the opposite party number 6 that they were accepting the marriage and ready to execute their marriage as per social caste custom and tradition, and requested the petitioner to allow the opposite party number 6 to go with them. And after a discussion, the petitioner allowed the opposite party number 6 to accompany with her parental members, family members, and awaited for early response of social marriage communication date. It is stated that after the opposite party number 6 remained with the opposite party number 7 and 8, they completely disconnected the contact between the petitioner and the opposite party number 6. And the opposite party number 6 was messaging to the sending message to the petitioner to take her away from the custody of or parental family members and to give information to the local police regarding illegal confinement. It is stated that the petitioner intimated the police, including SP Balaswar, SP Kendrapada, requesting them to rescue his wife, bracket opposite party number 6, and to give him in his jima but since no fruitful result came out, the petitioner, finding no alternative remedy, has filed this writ petition for the direction as aforesaid. When the matter was taken up on 26/6/2023, for the first time, the London Council for the State was asked to obtain a report from the opposite party number 4 as to whether opposite party number 6 was living voluntarily with the opposite party number 7 and 8, or she had been confined by them. When the matter was taken up on 14/9/2023, a direction was issued to the investigating officer to interrogate the opposite party number 6 as to whether she has been wrongfully confined in the house of her parents or voluntarily staying there. And whether any kind of marriage has taken place between her and the petitioner on 19/4/2023 in presence of their friends, relatives, and well-wishers, and whether any documentary proof like photographs or video recording are available in support of the marriage. When it was brought to the notice of this court that a marriage declaration document has been prepared in which both the parties have signed, and it was shown before Mr. A.K. Mahanti, Notary Public, Simulia, Baleswar, on 19/4/2023. Taking into account the various decisions of this court as well as the Honorable Supreme Court, and also the notification of the Law Department dated 18/3/2009, directing all the notaries across the state not to issue marriage certificate, which was not the function of notary under Section 8(1) of the Notaries Act 1952. We directed the IIC Balasore Town Police Station to intimate Mr. A.K. Mahanti, Notary Public, Simulia, Balasore, to appear before this court in person on 26/9/2023 to apprise this court as to on what basis he allowed the execution of marriage declaration document before him and under what authority he had attested such document. On the next date, that is on 26/9/2023, Mr. A.K. Mahanti, Ashwini Kumar Mahanti, Notary Public, appeared before this court and filed an affidavit wherein it was indicated that due to ignorance about the case laws and the judgment of the Supreme Court and this court, he executed the declaration of marriage document in favor of the executants. The Notary Public was asked to file relevant documents regarding his appointment as notary, his extension, and also enrollment certificate. And filed another affidavit explaining under what circumstances he executed marriage declaration certificate issued in favor of the petitioner and the opposite party number 6, and what documents he had verified to come to the conclusion that the marriage between the petitioner and the opposite party number 6 had already been solemnized on 19/4/2023 in presence of their friends, relatives, and well-wishers, as has been mentioned in the marriage declaration certificate. On 5/10/2023, the matter was taken off, and when an affidavit was filed in which an affidavit was filed by the notary public in which in paragraph number 9 and 10, it was mentioned as follows, quote paragraph number 9 and 10. The Learned Counsel for the state sought for some time on that day to interrogate the victim, and this court asked the Learned Counsel for the state to ascertain from the victim about the correctness of the averments made in paragraph 9 and 10 of the affidavit filed by the notary public Simulia Baleshwar. And it was further directed that if any photographs or video recording of the marriage or any other documents relating to marriage between the petitioner and the opposite party number 6 would be available, the same shall be produced on the next date. Further direction was issued to the investigating officer to visit Parvati Temple, Marcona, and ask the temple authorities whether any marriage has been in fact been taken place between the petitioner and the victim on the said day or not, and he shall also verify the register of marriage maintained by such temple, if any, to ascertain the veracity of the claim of such marriage. When the matter was listed on 9/10/2023, the Learned Counsel for the state produced the written instruction along with the statement of the victim recorded by the IIC Baidyanathpur Police Station Ganjam. And the Learned Additional Government Advocate also produced the letter dated 5th October 2023 of the IIC Simulia Police Station, along with the letter of the temple authority, that is the president of Sri Sri Baba Nilakanteswara Temple Management Committee, Marcona, wherein it is stated that what has been stated in that document, the jo delo se document ta koda hala kali jota deithile a sheet koricho ki xerox koricho dio na letter eta ache wait wherein it is stated that no marriage was held between the petitioner and the opposite party number 6 in the said temple. The statement of the opposite party number 6 was also produced before this court. in which she has stated that our marriage was solemnized before Notary Public Simulia Baleswar on 19/4/2023. On a bare reading of the letter of the temple administration authorities of Sejo Baba Nilakanteshwar and the statement of the opposite party number 6, it is apparent that the marriage declaration certificate contains false averment see marriage certificate declaration. That the averment is taken that the marriage between the petitioner and the opposite party number 6 କୋଉଠି ସେ ବାହାଘର କଥାଟା ଲେଖା ହେଇଥିଲା ଆମେ ପଢିଥିଲୁ ସେଦିନ ସେ ଯୋଉ ସେ ଟେମ୍ପୁଲ ହେଇଥିଲା କୋଉଠି ସେଟା ଲେଖା ହେଇଥିଲା
ଟେମ୍ପୁଲ ହେଇନଥିଲା
ହଁ
ଏଥିରେ ଲେଖାଇଲା ଟେମ୍ପୁଲ ହେଇଥିଲା ତାଙ୍କ ଆଫିଡେଭିଟ୍
କାହା ଆଫିଡେଭିଟ୍
notary.
ହଁ ସେ ହଁ ନୋଟାରୀ ଆଚ୍ଛା ନୋଟାରୀ ଆଫିଡେଭିଟ୍ ଦି page 19 କୋଉ ପାରାଟା କହିଲେ that now we both first party and so leading a happy so marriage conjugal life and that the said marriage between so performed in the ceremony observed in accordance with upon with the sanction of that said marriage between free from all that the parties not that
madam second page next 20 page
20
page 20 madam ନାଇଁ ସେଥିରେ ବି ଲେଖିଲା
Of the notary.
ନାଇଁ 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 ଆମେ ସେ ଦେଖିଥିଲୁ ସେଟା ସେଇଥିରେ କୋଉଠି ଅଛି ସେ ମ୍ୟାରେଜ ସାର୍ଟିଫିକେଟ ଲେଖା ହେଇଛି କୋଉଠି କହୁନାହାନ୍ତି ପଢି ଡିକ୍ଟେସନ ସେଦିନ ଦେଇଥିଲୁ
Page 19.
page
19 से जोटा କହୁଛନ୍ତି
In the matter of declaration of marriage.
ସେଇଥିରେ କୋଉ ଲାଇନ ଏ ଯୋଉ ମାନେ in presence of ଯୋଉ well wishers family ସେଟା କୋଉଠି ଗୋଟେ ୱାର୍ଡ ଟା ଅଛି ଏଇଠି ପରା ଏଇ ଉପରେ ଲେଖା ହେଇଛି ସବା ଫାଷ୍ଟ ପାର୍ଟ ସେଟା ଖାତାରେ ଲେଖା ହେଇଯାଇଛି ତ that the declaration made that there was a marriage between the petitioner and the opposite party number 6 on 19/4/2023 at Marcona Simulia Parvati Mandir in presence of their friends, relatives and well wishers is nothing but a false statement. The case was posted today and the Notary Public Ashwini Kumar Mahanti has filed another affidavit wherein he has stated that he had notarized the declaration of marriage executed between the petitioner and the opposite party number 6 dated 19/4/2023, which is not legally tenable in the eye of law. He begged unconditional apology before this court and undertook not to commit or repeat similar type of mistake in future. When a query was made to the London Lottery public as to whether any training program has been organized by the state government to apprise the notaries of the state regarding their duties and functions, what not to do, what to do, what not to do, in accordance with the Notaries Act 1952 and the Notaries Rules 1956, he answered in negative. There are number of decision of this courts, also the other high courts, including the Honorable Supreme Court, wherein in connection with this Notaries Act and Notaries Rules, several pronouncement has been made, and it seems that most of the notaries are not aware about the same. We direct the state government to arrange training program for the notaries of the state on regular basis through virtual mode, and also issue guidelines to them in terms of Section 8 of the Notaries Act regarding their functions, stop. It has also come to the notice of this court that sometimes deponents do not appear before the notary public to swear affidavit, and when it is an affidavits are produced before the notary public either by the advocates or by the advocates clerk, some of the notaries used to attest the same without verification of any documents, which is definitely in not consonance with law. Not only the notaries are required to maintain the register in terms of the aforesaid act and rules, but also to maintain on what date any affidavit or any document was notarized before them, and the signature of the party with swearing affidavit also to be taken, which would prove that the persons concerned in fact appeared before the notary public to swear the affidavits. We found that in the Notaries Rules 1956, there is a procedure under sub-rule 5 of Rule 11, which indicates that every notary shall permit the district judge or such officer as the appropriate government from time to time appoint in this behalf to inspect his register at such times, not often than twice a year, as the district judge or the officer may fix, and the district judge or officer appointed by the state government shall have power to lodge a report to the appropriate government for taking action against a notary. This procedure should be followed strictly to see that the notary public follow their function, carry out their function in accordance with the Notaries Act and rules. The London Council for the State has produced the written instruction from the IIC Baidyanathpur police station dated 6/10/2023, from which it appears that the victim opposite party number 6 stated that she was voluntarily staying with her parents and she denied any confinement made to her. Though she stated that she had signed the marriage declaration before the notary public at Simulia, Baleshwar. The statement of the opposite party number 6 also reveals that she is residing happily with her parents and there was no compulsion on her. In view of such a report furnished by the IIC Baidyanathpur police station along with the statement of the opposite party number 6, since there is no illegal confinement or wrongful detention of the opposite party number 6.
Statement also and a written note.
Written?
That is
She would have written lekhi nije dei.
Acha, and also
written.
and the
Written note.
written note of the victim. ତାଦେହରେ କଣ ଲେଖିଛି? ହଁ ବାପା ମାଙ୍କ ସହିତ ଭଲରେ ଅଛି, ବାଧ୍ୟବାଧକତା ନାହିଁ. We are of the view that there is no so and so, and therefore this writ petition is disposed of. A copy of the order be handed over to the London Council for the State, which will be forwarded to the Law Department. Secretary Law Department. Secretary Law Department to do the needful as per the observation made in this order. Yes, sir. Draft कर देगी ना नुकसान को देखेगा, है ना? That's in the matter as per the registration. Personal appearance of the notary. Acha, that in view of the affidavit filed about the unconditional so on, so it is accepted, and the personal appearance of the notary public is dispensed with. Writ petition is disposed of. Yes.
Quickly list item number 19.
May I please? May I?
Yes, proceed.
And in this case, already we have come across all the PW statements, PW 1 to 8. I'm just refreshing my lord. Here is the case of 302, 201, and 34, my lord. And as a 302 and 34, two persons were convicted, and another person was convicted 201, 34.
The appellant under 302,
302,
201.
Yes, my lord. And yesterday, my brother.
The two of them have died.
Died now. Okay. Now, the present appellant, Emily Vijay, my lord. Against him, the materials available: number one, extrajudicial confession, and number two, leading to discovery.
No, what about last scene?
Last scene, my lord, those persons were dead, my lord.
Oh, the informant.
Informant is the lead.
No.
Informant was dead, and also another person with whom they took the liquor, they have died, my lord. Chakradhar, my lord.
So, they could have stated about this last scene.
Yes, my lord.
They are now dead.
They are not dead.
They have not been examined. That is the reason. Okay. So, if
last occasion, my lord put a question regarding query about to get decisions that the extrajudicial confession before the village peoples
in the meeting.
In the meeting.
Yes.
And we also told, I think, that even though the PW1 stated about the same, and he accompanied the informant to the police station, but in the FIR, it is not mentioned that any meeting was held, and in that meeting, any extrajudicial confession was made. Rather, it is stated, whatever they see, ekutia kon pachala to kahidala na kon emti gota achi. That is in page number 40. Aji dino, page 40, last 5 lines. Aji dino duita bele. Dasaram Munda is not the petitioner.
No,
sorry, not the appellant.
No, yes,
so the person is dead.
Yes.
So siye gaଁ ku asi mu jai taku Dakua Munda ବିଷୟରେ ପଚାରିବାରୁ ସେ କିଛି ଜାଣିନି ବୋଲି ପ୍ରଥମେ କହିଲା। ପରେ ମୁଁ ଜୋର ଦେଇ ପଚାରିବାରେ ସେ ସ୍ୱୀକାର କଲା ଗତ ବୁଧବାର 15/3/2000 ତାରିଖ ରାତି ପ୍ରାୟ 10টাରେ ସେ ଓ ବିଜୟ ମୁଣ୍ଡା ବାବୁରାମ ମୁଣ୍ଡା ମିଶି ଡାକୁଆ ମୁଣ୍ଡାକୁ ଜୀବନରେ ମାରି ଫିଙ୍ଗି ଦେଇଛନ୍ତି। ଏ କଥା ଶୁଣିଲା ପରେ ମୁଁ ଓ ମାଟାର ମୁଣ୍ଡା ମିଶି ଦାସରାମ ମୁଣ୍ଡାକୁ ଧରି ଆପଣଙ୍କର ପାଖରେ ହାଜର ହୋଇ So it's not by the appellant.
No. Yes, sir.
It is no. The extrajudicial confession is not by the present appellant.
Yes,
it is by that co-accused.
Yes.
Dasram Munda is dead, na?
Yes.
Right. So,
and also, my lord, ask one question regarding the assault medical evidence that assault on the part of the chest. That is not there as extrajudicial confession. The statement that the
extrajudicial confession.
No, the evidence was there in chest, but no
chest re kichi injury
medical
nahi.
injury.
And I think
leading to discovery.
About the leading to discovery.
The recording was not there.
27, right?
Yes,
27 recording is not there. And another thing, I was going on that day.
Yes,
actually, the leading to discovery was by that person.
But
it is
not by the spot.
No, it is not by the appellant. First, you see, please come to page 73. That IO's evidence.
First paragraph, second line. During examination.
Further examination 17/1/2005 jota achi, page 73. Please read it out.
May?
73 ro podon.
Yes, ma'am. The informant Mangal.
This is chief examination.
Yes, ma'am. Chief. The informant Mangal Benkar came to the beat house along with Matai Benkar, along with accused Dasra Munda. During
confession
yes, ma'am.
Yes.
During examination of Dasra Munda, who confessed his guilt regarding murder of Dakua Munda, along with Vijay Munda and Babura Munda, accused Dasram also confessed before me that they concealed the dead.
He means the IO.
Yes.
This is the IO. Yes.
The dead body inside the safety tank of the Epitata, and while he was in custody, He also led me to the place of concealment of the dead body at Ipitata. And in order to give the recovery of the dead body to me, accordingly, 23 2000, I, along with the informant Mangal Bendkar, Matai Bendkar, uh, Narendra Kumar Raj, and the executive master Barbil entered into the premises of Ipitata, and the accused Dasara Munda
Again,
pointed
Dasara Munta.
Yes.
See that, yes.
Dasara pointed out the place of concealment of dead body. The dead body was concealed inside the safety tank, and after lifting the cover of the tank, I saw the dead body was floating inside the tank, and lifted the dead body to the ground. The informant and others identified the dead body of Dakwa Munda. Then I held the inquest over the dead body in presence of the witnesses. Exit 5 by 2 is my signature, exit 5. Then I sent signature on exit 5. And then I sent the dead body to Champua SD hospital on requisition. Exhibit 14 is the dead body challenge. Exit 14 by 1 is my signature. I also apprehended on
No,
20.
just take pause for a moment.
Yes, ma'am.
So, Mr. Das, এই जो आमे पढ़ुचु এই statement ରୁ जणा पड़ुची, it was not at the instance of this present appellant. It was at the instance of it was at the instance of that person who is dead. Apart from the fact that तार तो 27 statement नहीं जा भी नहीं, किंतु एटा आउ तापरे law is very clear that once a fact is discovered, it cannot be rediscovered. Right? You see, तापर से कौन कहूची, माने आइयो, please continue.
Yes, ma'am. Then I also apprehended 23 2000 that the accused Vijay Munda and Baburam Munda. Yes, my lord. Present appellant and the Baburam Munda. From their village at about 9 to 9:30 a.m. Accused Vijay and Baburam were also present near the place of concealment, and they also pointed out the tank inside which the dead body was concealed. We entered to the premises of Ipitata and arrived the place of concealment at 10:45 a.m. of 23 2000. The accused Baburam and Vijay also confessed their guilt of committing the murder of Dakwa Munda along with the accused Dasara Munda, and after committing the murder, they concealed the dead body inside the safety tank.
This has already been recovered. Thereafter, this happened. Okay. So now you can read out. The accused Baburam
led me.
Baburam means not another accused.
Yes, Baburam led me to the place where they concealed the wooden balla of Asan variety and a red color banyan with blood stain, and gave recovery of the same in the presence of the witnesses. Accordingly, I prepared sigil list exhibit 15. This is a said sigil list exhibit 15 by 1 is my signature. Then the accused person led me to Karan Sahi Chakka, where they have committed the murder of Dakwa Munda. I collected sample earth blood stained earth from the spot. The stone weighing more than 1 kg, being stained with blood, was recovered from the place of occurrence at the instant of the
केवल विजय मुंडा टू जानो गोटे पत्थर जार येटा होची 1 kg सेती हां हां तार 27 स्टेटमेंट नाही आउ
PW7 मध्ये क्रॉस एग्जामिनेशन कहिसंती जे मु गली एते मते फास्ट कहि देले जे आमे रिकवरी कलु विजय वाज प्रेजेंट देन से आई हैव नॉट सीन विजय देयर मते इंस्ट्रक्शन दे पत्थर उठेली त लॉक रक्त भी लागि नथिला
27 ए PW7 से होची से स्टोन रो
यस मैन
लेट अस सी दैट
PW7 right page 70 mile.
Oh, अच्छा. Oh, please read it out.
May I read chief and
आइयोरो मिस्टर दास आइयो स्टेटमेंट रु जणा पड़ला जे से जो प्रथम अक्यूज सी ऑलरेडी से गुडा डेड बॉडी से टैंक देखे दितला सो दैट इज नो वे कंसर्न विथ आंसर आउ से जो गुडा कोन बाडी ना कोन सेटा बोलला सेटा हला से जो आरो जोटा 20201 दिस अक्यूज सो फार इज कंसर्न से जो पत्थर गोटे now the witness to that seizure perhaps is this PW7.
Yes, ma'am.
Please read it out.
I know the accused Vijay Munda. Only the occurrence took place about 4 to 5 years back. In an afternoon, I went to spot where the dead body was concealed. Accused Vijay led police to the spot for discovery of the dead body. I lifted a stone from the ground and kept inside the police jeep. It is a fact that accused Vijay admitted his guilt and told that on 15/3/2000, on Wednesday at night, he, along with others, committed murder of Dakua Munda and shown the place of occurrence, and gave recovery of small stones stained with blood of having 1 kg weight. Vijay Munda was with police. The stone which has been referred to me in the said stone, which Vijay handed over to police in my presence by stating that he, along with others, has committed murder by means of stone. MO7 is the said stone. Then police prepared a report and I put my LTA on it. Then cross examination. I put LTA on a written paper. I had not gone to the place where the dead body was concealed. I cannot say how the accused persons committed murder of deceased. The police instructed me to leave the MO7 and keep it inside the police jeep. I cannot say whether there was bloodstain MO7 at the time of my lifting. Vijay Munda was not there at the spot.
Oh, this is how can then be a 27? No statement, and the person concerned at whose instance he was
Yes.
not there. So how can
Only in the chief he has stated that Munda handed over to the police in my presence. The
ପ୍ରଥମେ ସିଏ କହିଲା ମୁଁ ନିଜେ ପୁରା ଉଠେଇଲି
no, no.
Oh, no.
The state.
ଆପଣ ରୁହନ୍ତୁ ଆସନ୍ତୁ ଚିଫ ଏକ୍ସାମିନେସନ ଆଉ ଥରେ ପଢ
last fourth line.
ନା ନା ପ୍ରଥମେ ଆଗେ ଦେଖନ୍ତୁ ଆମେ accused Vijay laid so and so I lifted a stone from the ground and kept it inside police jeep. ତାପରେ ପୁଣି କହୁଛି Vijay handed over the police to in my presence. ତାପରେ ତୃତୀୟରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହିଲା ଯେ ବିଜୟ ଟୋଟାଲି ନଥିଲା ଆଉ ଏଇଟା କୋଉଠୁ କଣ
ସେଇଟା କଣ୍ଟ୍ରାକ୍ଟ
ବାକି ରହିଲା ସେ ମିଟିଂ କଥାଟା କୁହନ୍ତୁ ମିଟିଂ ତ apart from the fact that it is not there ଆଉ କୌଣସି ୱିଟନେସ୍ କହିଛନ୍ତି
Only PW1 clearly states the meeting re, as my lord assumed that more than 10% may be there. Out of them, only PW1 was examined, and that wife, she has stated different. PW5, the wife of the deceased. Her statement is not clear about this meeting, but subsequently, I thought it might have been come to knowledge of the PW5. That's why I cited other day her statement. And my lord, otherwise PW1, PW5 goes now. PW4 is the security guard, my lord. Security guard clearly states in his cross examination, after taking permission, police entered. And there are 2 to 3 persons who are along with the police. But what comes out to statement of the PW8, there are more than 4 officers. Thereafter, my lord, this is the PW1. And others were also present that has been mentioned in the deposit.
We are on that village meeting. Village meeting the PW1 और PW4 5 ଦି ଜଣ ତ କହୁଛନ୍ତି
main confined was PW1 actually. PW1, may I read my PW1 statement?
ସେଇ part ଟା ପଢନ୍ତୁ କାରଣ
yes, in the chief it has been mentioned at page 56 my lord, from the bottom ଉପରକୁ ଆସିଲେ 7th 8th line. Then we convened a meeting.
କୋଉଠି ପଢୁଛନ୍ତି
my lord, at the middle portion of the deposition, my lord.
ପାଇଲେ. Then we convened a meeting.
On Friday 17/3/2000 in the morning hour. The meeting was held in front of house of Chakra Mahakud, who is now dead. In meeting, Mangala Benkar, he is also dead, the informant. Chakra Mahakud, Buntia Mahakud, Judia Munda.
You said on that day that none of them have been examined.
Examined, my lord.
Okay.
And the accused Vijay and Dasara Munda, along with other people, were present. My lord, important thing, 17/3/2000 kindly be appreciated. 17/3/2000 it was made. The FR was lost 19.
It is not there.
Exactly.
This part is not there in the, we have said already that extrajudicial confession.
And date is also wrong.
No, you are leaving one thing.
Yes, my lord.
Even though this, the lady, that means PW5,
she was not there.
Stated about the confessional, extrajudicial confession in the meeting. But this man has not stated that PW5 was present in that meeting. Has he stated?
No, my lord. He has not.
Verify again once.
No, I am reading again, my lord. This part is the Mangala Beltkar, Chakra Mahakud, Sunita Mahakud, and Judia Munda, Manju Munda, Chakra, along with other people were present in the meeting. It was asked to the accused Vijay and Dasaram that Tome Sangare, Tomo Sangare, Dakua Munda Buluthila, Kuade Gola, and the accused Vijay and Dasaram confessed their guilt of committing murder of Dakua Munda in the night of 15/3/2000. They committed murder of Dakua, suspecting him a practitioner of practicing quack gunia. They assaulting him in large size boulder over the head of the head and chest of the
चेस्ट
deceased.
पे जोटा कहूँ हमें नो इंजुरी बोली
Yes.
आज पर डॉक्टर किए
Dr. PW2, my lord.
PW2.
Yes, my lord.
Okay.
Hmm.
Then he, along with the others, thereafter went to that outpost. FIR was lost, and in which that is not there about.
My lord, one more thing, if you will appreciate.
Yeah.
A crux is here. The FIR was lost on 19. But in meeting was held on 17.
17.
2 days after they have lost the FIR. But they are saying here they have gone immediately thereafter. And here Baburam, the Dasram and also Vijay, present appellant, both were there at the relevant point of time. But Dasram was arrested at the relevant point of time actually. On the very next day he was arrested. I'm sorry. It was shown that on 19th he was taken in the custody. And 20th
He was arrested.
He was arrested.
Yes.
And 19th it was verified first. କଣ ହେଇଛି ନା ଆମେ ଟାଙ୍କିରେ ବୁଡି ରଖୁଛୁ ଦେଖିଲେ କି ରାତି ହେଇଥିଲା ବହୁତ ବୋଲି PW1 କହୁଛନ୍ତି we could not recover that.
That was at the instance of the other accused, not at the instance of the petitioner.
Yes, man. Appellant instance.
Vijay Munda is not in picture right now.
Exactly.
Because
Vijay-
IO
Yes,
has
my
also stated that on
we are
20th he is
concerned
arrested.
Yes.
because Vijay was arrested on 20th, not on 19th.
No.
19th only one accused was available with the IO.
Yes, man.
That is that Dasara
Dasara.
Munda, right?
Yes, man.
PW5 says that in the meeting he acts, he has not got any information regarding whereabouts of
PW5 हाँ जो आर लोग से कौन
Laguri.
कहूँ जी
particular meeting में पहुंचा है कि जो whereabouts पाया नहीं. That is in the page 62 and 5.
अच्छा कौन कहूँ जी ने
Turi Munda.
I inquired the whereabouts of my husband from it's a meeting रे by the time my husband left home to arrange so and so अच्छा we convened a meeting last two lines of page 66 we convened a meeting in our village in the morning. By the time my husband left home to arrange money, he went along with
The prior
to the village meeting on Friday morning. I inquired the whereabouts of my husband from Dasaram Munda, but he told that my husband had gone to Holia.
Rauliya Puja Rauliya House. For Rauliya House.
But in the meeting, nothing disclosed regarding whereabouts of my husband, as a result of which so and so went to the police station to lodge the. That means he contradicts the version of PW1 that in that meeting any disclosure was extrajudicial confession was made.
Right. That's what they in the FIR there is nothing mentioned.
ଆପଣ ଆଣିଛନ୍ତି କି ସେ ଯୋଉ
Yes.
meeting ର
My lord, one judgment, my lord, regarding extrajudicial confession only, and one more regarding my lord 27 ought to be recorded. If it will not be recorded, ample
is
evidence
there.
required. My lord was given the citation of 84. Yes, my lord. That is there. That I have not, but latest Supreme Court judgment, my lord, so short.
Recently, 2023, 3 decisions of the Supreme Court on the basis of the extrajudicial confession. Yes, but it I have also gone through that.
में जो meeting का था
Meeting also extra.
No, in your support or against you?
Definitely.
Assisting a lot.
so
My lord, here, my lord,
pass on this
It's a judgment also against.
JCRL number 11 of 2008. The appellant Vijay Munda, along with Batua alias Dasaram Munda and Baburam Munda, faced trial in the court of Additional Session Judge Fast Track Champua in ST case number 23/198 of 2004-2000 for offences punishable under section 302/34 of the Indian Penal Code on the accusation that on 15/5/2000 at 10 p.m. at Sahi Joda, they committed murder of Dakua Munda, hereafter the deceased, in furtherance of their common intention. And they were also charged under section 201 by 34 of the Indian Penal Code on the accusation that having reason to believe that the offense of murder has been committed, they concealed the dead body of the deceased in a latrine tank for screening the offenders from legal punishment in furtherance of common intention. Stop. The Lennon Trial Court wide impugned judgment and order dated 31/1/2005, though acquitted the accused Baburam Munda of the charge under section 302 of the Indian Penal Code, but convicted him under section 201 by 34 of the Indian Penal Code, and he was sentenced to imprisonment which he has already undergone. So far as the appellant Vijay Munda and accused Batua alias Dasaram Munda are concerned, the Lennon Trial Court found them guilty under section 302/201 by 34 of the Indian Penal Code and sentenced each of them to undergo RI for life for the offense under section 302 by 34 of the Indian Penal Code. However, no separate sentence was awarded for the offense under section 201 by 34 of the Indian Penal Code. Stop. Next para. The prosecution case, as per the first information report lodged by one Mongol Bentekar before the officer in charge, no? Before the officer in charge of PW8, na?
Yes, on PW8.
Okay. Acha. Before Joda police station kar diyantu. On 19/3/2000 is that? Okay. Before acha. I was at registered lodged at Baliapada Beat House, which was subsequently registered at Joda police station. Right. Is that the deceased was his nephew and he was aged about 40 years. And on 15/3/2000, he, along with the deceased, had been to the house of one Chakra Mahakur at about 8 p.m. to consume handia. After some time, the appellant Vijay Munda and accused Dasaram Munda came there. And at about 10 p.m., both the appellant and the accused Dasaram Munda called the deceased to take him to the home, to his house. And the informant also followed them. On the next day, in the morning hours, PW5 Turi Munda, the widow of the deceased, came to the informant and informed him that since last night the deceased had not returned home. Hearing this, the informant as well as PW5 searched for the deceased, but they couldn't find the whereabouts, his whereabouts. The informant also went to the house of the appellant and the accused Dasaram Munda to ask them about the deceased, but they were found absent in their respective houses. On 17/3/2000, in the morning hour, a meeting was convened in which PW1, PW5 and others were present, and decision was taken to report the matter in the outpost, Bilei Pada outpost. And accordingly, PW1 and PW5 were sent to the outpost to report. And to make a request to trace out the deceased. It is stated that on 15/3/2000 night, the deceased had worn a full pant and red color banyan, and the informant was trying to locate the appellant as well as the accused Dasaram Munda. It is stated that the accused persons were suspecting the deceased to be performing witchcraft. It is further stated in the FIR that on 19/3/2000 at about 2 p.m., the informant came to know that the accused Dasaram Munda had returned back to the village, and accordingly he approached the accused and asked him about the whereabouts of the deceased. But though he first pleaded in ignorance, but when the informant compelled him, accused Dasaram Munda confessed before him that on 15/3/2000 at about 10 p.m., he, along with the appellant Vijay Munda and accused Baburam Munda, had committed murder of the deceased and threw the dead body. Accordingly, the informant, along with PW1, PW1, along with the accused Dasaram Munda, came to the outpost and lodged the oral report before PW 8 জপবন্ধু না জগবন্ধু জগবন্ধু ত্রিপাঠী, SI of police, which was reduced to writing, and it was read over and explained to the informant, and since the report revealed and the informant put the signature, and since the report revealed a cognizable case under section 302(201)/34 of the Indian Penal Code, it was sent to officer in charge of Joda police station for registration of the case, and one SS Mishra, the OIC of Joda police station, registered Joda PS case number 44 dated 19/3/2000 under section 302(201)/34 of the Indian Penal Code against the appellant and accused Dasaram Munda and Baburam Munda. As per the direction of the OIC of Joda police station, PW 8 took up investigation of the case, and during course of investigation he examined witnesses, and the accused Dasara Munda confessed his guilt before him and stated to have concealed the dead body in a safety tank of EP Tata, and accordingly led the police party to the place of concealment of the dead body on 19/3/2000 to give recovery. Stop. On 23/2000, the IO bracketry PW 8 along with the informant and others, so also the executive magistrate Barbil, entered into the premises of EP Tata, and the accused Dasara Munda pointed out the place of concealment of the dead body, which was inside the safety tank, and after lifting the cover of the tank, the dead body was found floating inside the tank. The dead body was lifted to the ground, and the informant and others identified the dead body to be that of the deceased. PW 8 held inquest over the dead body in presence of witnesses and prepared inquest report Exhibit 5. The dead body was sent to Champua SD Hospital on police requisition for post-mortem examination, where PW 2 Dr. Benudhar Mudali conducted autopsy over the dead body and noticed some injuries on the person of the deceased and opined the cause of death of the deceased due to shock from intracerebral laceration and hemorrhage, and submitted his report Exhibit 2 to the investigating officer. The IO bracketry PW 8 apprehended the appellant, so also the co-accused Baburam Munda, on 23/2000 from their village And at about 9 to 9:30 a.m. and both the accused also pointed out the tank inside which the dead body was concealed. The IO again entered the place of concealment, that is the premises of Epistata Tata, on 23/2000 at 10:45 a.m. and at the instance of accused Baburam Munda, a balla was recovered. So also balla and a red color banyan with bloodstain was recovered, and seizure list exhibit 15 was prepared. The IO collected sample earth and bloodstain earth from the spot, and at the instance of the appellant, one stone more than 1 kg was stained with blood was recovered from the place of occurrence, and seizure list by exhibit 16 was prepared. Another stone weighing more than 2 kg was recovered under a mahua tree as per the at the instance of accused Dasaram Munda, as per which was seized as per seizure list exhibit 17. The IO prepared the spot map exhibit 18 and sent the accused persons for their medical examination. The biological samples were collected. The wearing apparels of the appellant was seized under seizure list exhibit 20. So also the wearing apparels of the other two accused persons as per seizure list exhibit 21 and 22. One Hercules cycle was seized as per seizure list exhibit 1, which was given in the Jima of one Kangamunda as per Jimanama exhibit 23. The seized stones, bracketed 2 numbers, were sent to the medical officer who conducted post-mortem examination of the dead body with a query as to whether the injuries found on the body of the deceased at the time of PM would be possible by such stone, and the query report was obtained, and the exhibits were sent to SFSL Rasulgarh through JMFC Barbil, and on completion of investigation, charge sheet was submitted against the accused persons, including the appellant, under section 302(201) by 34 of the Indian Penal Code. The defense plea of the appellant was one of denial. In order to prove its case, the prosecution examined 8 witnesses. So you make it, and the following exhibits were so and so we did, and material objects so and so do it. Okay. The London trial court, after analyzing the ocular as well as the documentary evidence on record, came to hold that there is no direct evidence in this case relating to the commission of murder of the deceased, and the case is based on circumstantial evidence. The Lenin trial court relied upon the evidence of leading to discovery of the dead body as well as the weapon of offenses, and came to hold that the recovery in consequence of the information given is fortified and confirmed by the discovery of the wearing apparels and the dead body of the deceased, which were kept in a bony bag inside the safety latrine tank of EP Tata, and the wearing apparels of the deceased, which led to believe that the information and the statement given by the accused persons before the IO are not false, were not false. It was further held that there is no missing link to disbelieve the confession of the accused persons under Section 27 of the Evidence Act. The Lenin trial court further held that the place where the dead body was recovered was inside the premises of EP Tata. Until the recovery of the dead body, nobody except the accused persons knew about the place that is inside the safety latrine tank of EP Tata. And accordingly, it was held that there is no other hypothesis than to hold the appellant Vijay Munda and the Saram Munda to be guilty for committing the murder of the deceased, and to hold the Baburam Munda for helping the appellant and the Vijay Munda and the accused Dasaram Munda in disappearing the evidence of the offense they committed. Mr. Saugata Das, Learned Counsel, appearing for the appellant, contended that the informant Mangal Bentkar could not be examined during trial as he was dead, and the entire case of the prosecution, though based on last scene of the deceased in the company of the appellant Vijay Munda and Dasaram Munda, since the informant has not been examined, informant as well as one Chakra Mahaku have not been examined, the said fact could not be proved. The Lenin Counsel further argued that though it is the prosecution case that extrajudicial confession was made by the appellant Vijay Munda and accused Dasaram Munda in a village meeting, whereafter PW1 proceeded with the informant to lodge the FIR, to lodge the written report. But in the first information report, there is nothing about the extrajudicial confession made in any village meeting. Therefore, in all probability, such an evidence has been created afterwards to falsely implicate the appellant. The Land Council further argued that though in the extrajudicial confession made in the village meeting, it is stated that with a large size boulder, the assault was made on the head and chest of the deceased. But the post-mortem report indicates there was no injury on the chest of the deceased, which falsifies, which contradicts the manner of assault as narrated, as allegedly made in the extrajudicial confession. The Land Council further argued that though PW5 was present in the village meeting, but she has stated that in the meeting nothing was disclosed regarding the whereabouts of her husband. Therefore, it creates doubt whether any village meeting was convened at all or not, and if so, whether there was any extrajudicial confession made before the villagers. The Land Council further argued that in a scenario in which the extrajudicial confession stated to have been made by the accused persons, it cannot be said that it is a voluntary one, and therefore it is not admissible in the eye of law and cannot be utilized against the appellant. The Land Council further argued that so far as the leading to discovery of the dead body from the safety tank of EP Tata is concerned, the same was at the instance of accused Dasaram Munda. And so far as the appellant is concerned, it is stated that only a stone weighing more than 1 kg was recovered at the instance of the appellant. The Land Council further argued that since the prosecution has failed to establish the last seen part, and if the extrajudicial confession made in the village meeting is discarded merely because at the instance of the petitioner 1 stone was recovered, it cannot be said that the chain of circumstances is so complete to unerringly point towards the guilt of the appellant. Therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. More so, said like there were 27. More so when the statement under section stated to have been made under section 27 of the Evidence Act has not been recorded. Mr. Arupananda Das, Land and Additional Government Advocate, on the other hand, supported the impugned judgment and submitted that since the place of concealment is such that it was within the exclusive knowledge of the accused persons, and it was pointed out by the co-accused Dasaram Munda, and due to unfortunate death of the informant as well as one Chakradhar Mahakut, the last scene theory could not be established. Still then, it cannot be said that the London Trial Court has committed any illegality in convicting the appellant. Adverting to the contention raised by the London Council for the respective parties, law is well settled that in a case which is based on circumstantial evidence in order to convict an accused, the following things are to be taken into account. Sarda Britchans quote kar de Panchasid. Admittedly, in the present case, the informant Mangal Bendkar could not be examined due to his death, and though in the first information report, it is stated that on 15/3/2000, the deceased was in the company of the appellant and the co-accused Dasaram Munda, but the same being not a substantive evidence, we cannot take into account such narration regarding last scene in the FIR. The extrajudicial confession has been stated by PW1, who has stated that on 17/3/2000 in the morning hour, a meeting was convened in front of the house of Chakra Mahakud, and in that meeting, number of villagers were present, including he himself, where the appellant Vijay Munda and Dasaram Munda were asked about the deceased, and both of them confessed their guilt in committing murder of the deceased in the night of 15/3/2000. They further stated that they committed the murder suspecting the deceased to be practicing Quack bracketry Gunia. And they further confessed that they assaulted the deceased in a large size boulder over the head and chest of the deceased. PW1 has stated that after the extrajudicial confession, he, along with the informant Mangal Bendkar and others, went to Bilaipada outpost to lodge the report. And accordingly, as per their version, the police scribed the FIR in their presence, and it was read over and explained to them, and Mangal Bendkar put his LTI on the same. Most peculiarly, the extrajudicial confession part in the village meeting is conspicuously absent in it. Therefore, it creates doubt as to whether any village meeting was organized prior to the lodging of the first information report, and if so, whether any extrajudicial confession has been made by the appellant and the co-accused before the other villagers. PW5 is stated to be present in that meeting, who is none else than the widow of the deceased. And she has stated that in the meeting, nothing was disclosed regarding the whereabouts of the husband, as a result of which she, along with the informant and PW1, came to the police station to lodge the FIR. Therefore, even though the prosecution has adduced the evidence of two witnesses, that is PW1 and PW5, relating to the village meeting, but whereas PW1 has stated about the extrajudicial confession made by the two accused, the evidence of PW1 is completely silent. PW5 is completely silent in that respect. When the first information report also doesn't indicate about any extrajudicial confession made in the village meeting, it is very risky to place any reliance on this part of evidence of the prosecution. Moreover, in view of the settled law laid down by the Honorable Swans, meeting decision wherein it is held like this, that it cannot be said that the confession, if any, was voluntary in nature, and therefore it cannot be acted upon. If the confessional part is taken out of consideration, the only material remains against the present appellant. Moreover, even though it is stated in the confessional statement, stated to have been made in the village meeting, that a large size boulder was used in assaulting the deceased on his head and the chest. But after going through the evidence of the doctor who conducted post-mortem examination, we find that there is no injury on the chest of the deceased. Therefore, the medical evidence doesn't corroborate to the manner of assault as narrated in the extrajudicial confession. Now you come to that part. The only material remains is the leading to discovery of one stone which is more than 1 kg. Though PW8 has stated that the appellant stated about the commission of murder of the deceased, and the stone was recovered at the instance of the appellant, but he has not stated about recording of the statement of the appellant under section 27 of the Evidence Act. In case of so and so, dekhiye debe 27 mein jo, if that is not. In view of the available foregoing discussions, when the motive behind the commission of murder of the deceased has not been clearly established, and the circumstances which has been proved by the prosecution, like extrajudicial confession in the village meeting, is not believable as per the reasons already assigned. And when the leading to discovery of the stone suffers on account of non-recording of the statement of the appellant under section 27 of the Evidence Act, it cannot be said that in view of the available material on record, the prosecution has successfully established the guilt of the appellant under section 302 and 201, read with section 34 of the Indian Penal Code. we are of the view that the Lennon trial court has not kept in mind the settled principle of law and the not appreciated the materials on record in proper perspective. Law is well settled that there is a wide gap between may be true and must be true, and the prosecution has to travel the entire distance by cogent evidence. We are of the view that the conviction of the appellant under section so and so is not sustainable in the eye of law. Accordingly, the impugned judgment and order is set aside. The appellant is acquitted of the charges under section 302(201) by 34 of the Indian Penal Code. He is on bail or he is in custody?
Yes, sir.
On bail.
He is on bail.
Bail.
So the bail bonds and the surety bond stands cancelled.
Sure, sir.
All right. Put a note of appreciation on the efforts of you are amicus curiae, na?
Amicus.
So pay the amount 7,500 and also Mr. Das or Upananda Das can. So let us take off another matter. Let's begin with.
Item number 20.
May I please?
What is the information, Mr.
Alif.
Alif. What was it? किस जन appellant अछंती
Single.
ये पेपर बुकटा दियो
One appellant.
अच्छा one appellant पेपर बुकटा दियो The Land Council for the state has produced written instruction received from IIC Aska Police Station dated 7/10/2023 that the appellant Surya Narayan Muni alias Kuna Muni is alive and presently residing at Muni Sai Aska. The written instruction is taken on record. Return young. Yes, place your matter.
Yes, ma'am. Here is appellant.
Direct evidence or circumstantial?
Direct.
Direct evidence. So, what are the charges? Let us come to the charge first. Page 25.
Yes.
Read it.
So, is hereby you Surya Narayan that you are about 29th day of August 2022 at about 9:30 a.m. in the premises of Tribedeshwar Temple of Aska committed murder intentionally causing the death of Prakash Chandra Muni and hereby committed an offense punishable under section
Please read the FIR.
Yes, ma'am. Page 21. ମୁଁ କାଳୀଚରଣ ମୁନି
PW?
PW 6.
PW 6. Okay. Please proceed.
ମୁଁ କାଳୀଚରଣ ମୁନି ଲେଖି ଜଣାଇବାର ରିପୋର୍ଟ ଏହିକି ଯେ ଆଜି ଦିନ 29/8/2002 ସମୟ ପ୍ରାୟ 9:30 ଦିବା ସମୟରେ ତ୍ରିବେନ୍ଦ୍ରେଶ୍ୱର ମନ୍ଦିରରେ ପୂଜକ ଶ୍ରୀ ପ୍ରକାଶ ଚନ୍ଦ୍ର ମୁନି ରାନ୍ଧୁଥିବା ସମୟରେ ସୂର୍ଯ୍ୟ ନାରାୟଣ ମୁନି ଓରଫ କୁନା ମୁନି ପିତା ଜଗନ୍ନାଥ ମୁନି ସାନ ମୁନି ସାହି ଆସି ଅଶୋକ
ଏଗୁଡ଼ା ସେମିତି କୁହନ୍ତୁନି ସେ କିଏ ଆକ୍ୟୁଜ କିଏ କଣ ସବୁ କହିବେ ନା ଆଉ କଣ ପଢି ଦେଇଗଲେ କଣ ହବ?
प्रकाश चंद्र मुनि डिसीज हला प्रकाश चंद्र मुनि
ଆଚ୍ଛା ଇଏ ହେଲା ଡିସିଜ ଓକେ
Yes.
ରାନ୍ଧୁଥିବା ସମୟରେ
शांतिवा समय
ସିଏ
सूर्य
ଡିସିଜ
नारायण
ରହୁଛି ମନ୍ଦିରର ପୂଜକ ଓକେ
Yes.
ହଁ ସେଠୁ କଣ ହେଲା?
सूर्य नारायण मुनि
ସୂର୍ଯ୍ୟ ନାରାୟଣ ମୁନି ମାନେ ଇଏ ହଉଛି ଆପେଲାଣ୍ଟ
Yes.
ହଁ କଣ ହେଲା?
आसी असभ्य भाषा गाली गुलज करिया परे
ହୁଁ
प्रकाश चंद्र मुनि रोषशाळारू असभ्य भाषा मंदिर मध्य गाली गुलज न करिया पई कहिथिले
ଓକେ
तापरे से रोषशाळारू मंदिर पाखकू गला बेले त्रिवेंदमपुर गर्भगृह सामनारे थिबा बुसब पाखरे प्रकाश चंद्र मुनि को एक धारुआ छुरी रे डाहाण पट पेट पाखरे ओ बाम पट भाग ओ पंजेरा हाड़ मध्यरे ओ बाम पट कांधरे धारुआ छुरी भूसी दौड़ी पळाइथिला मु
थ्री ब्लोज
थ्री ब्लोज
ओके ହୁଁ
मु प्रकाश चंद्र मुनि को धरिथिबा अवस्थारे अन्य केते जण पुना मुनि को धरिया पई गोड़ाइथिले प्रकाश चंद्र मुनि अवस्था गुरुतर होइथिबा हेतु मु तांकू एक ऑटोरे डाक्तरखाना पहुंचाई देली
ହୁଁ
तांकर अवस्था अत्यंत गुरुतर होइथिबारु डाक्तर माने श्री प्रकाश चंद्र मुनि को ब्रह्मपुर मेडिकल कॉलेज हॉस्पिटल को एम्बुलेंस द्वारा चिकित्सा पई स्थानांतरित करदेले
ହୁଁ
तापरे मु चिकित्सा व्यवस्था सारी उक्त एफआईआर देवा पई आसिली आर विरुद्ध विचार करी दोषी को उपयुक्त दंड दिया जाय बोली आपण
So case was registered under 324, 326,
Yes.
307.
Yes.
When the deceased died,
After 4 days on
4 days.
3/9/2002.
Acha, death. Okay, now who are the eyewitnesses?
PW1 367.
PW1,
367.
PW3, PW6 and PW?
7.
Okay.
PW is a doctor of PM.
Acha, PM hela, PW8 hela doctor.
Miller.
PW10 IU.
PW10 IU.
And PW11 is the doctor first examines.
अच्छा से जो इंज्योर्ड जेतବେଳେ ଥିଲା गोटे हॉस्पिटल रे सेठी डेथ हला ना आ कोठी शिफ्ट
नहीं
हला
आस्का हॉस्पिटल ले फर्स्ट ट्रीटमेंट हले तापर एमकेसीजी रे
ओके आस्का देन डेथ हला एमकेसीजी रे
एमकेजी
No MO mark.
PW10 हला आईओ ओके आ गोटे कोन आईओ डॉक्टर कहउथिले कोन
A PW11.
हां से कोठी कर डॉक्टर
आस्का
आस्का आ ये जो PW8 होची एमकेसीजी रे
PM.
एमके
एम अच्छा एफएमटी आउ ये जो 1 3 6 7 होचंती all are eye witnesses okay so you place that let us start with one eyewitness
yes one
समस्ते इंडिपेंडेंट ना कि अछंती ना सब गुडा रिलेटेड
रिलेटेड
all are
अछंती
इंडिपेंडेंट की अछि
इंडिपेंडेंट एक अछि
एकटा तो एकटा कोन
से दूर संपर्क बोली कहचंती
हां एकटा पढन दो
PW1 I know accused Suryanarayan Muni as well as the deceased Prakash Chandra Muni. The deceased died in the intervening night of 2002 at MKCG Medical College Hospital, Barampur. The occurrence took place on 29/8/2022. On that day at about 9:30 a.m., I had been to Trivandeshwar temple to worship. River Rushikalya flows the side of the temple towards south. First, I went to River Rushikalya to wash my leg, and while coming to temple, I had exchange of words between the accused and deceased, and saw accused Suryanarayan Muni stabbed on the belly on both sides, on left arm towards upper and on left shoulder by means of knife. As a result, the deceased sustained bleeding injury.
चारिटा इंजुरी हिची ना अब बोथ साइड कोची बेली रो
both side belly रहला shoulder रे
हां ना नहीं एटा तो दीटा रहला बाकी बेली रो दी साइड माने भाउची चारटा बोदे
Doctor देछि
all will see that yes please continue
shoulder means spine. Seeing the incident, I ran towards accused, but he fled away towards Jagannath temple, taking knife with him. Thereafter, I, along with others, shifted the injured Prakash Muni to Aska Hospital. The doctor at Aska Hospital referred the injured for further treatment to MKCG Medical College Hospital, Barampur.
Yes.
The injured was shifted to Barampur, where he died while undergoing treatment. On 3/9/2002 at about 9:30 to 10 am, the police had inquest over the dead body of Prakash Muni at MKCG Medical College Hospital, Barampur, in my presence, and prepared inquest report marked Exhibit 1 and Exhibit 1/1 is my signature thereon. The Trivandeshwar temple, situated in the cross-examination outskirts of the Aska town. I cannot say exact length and breadth of the premises of the temple. The Trivandeshwar temple has its own compound wall. The main entrance gate of Trivandeshwar temple faces towards north. There are also other gates towards east, west, and south of the temple. The Phentaghara of Kalinga Pasya Samaj, situated adjacent west of the temple premises, adjoining to main entrance gate. There is an ideal of Lord Ganesh outside the temple, facing towards south. Occasionally, I used to go temple Trivandeshwar. At the time of washing my feet, there might be 2 to 3 persons present near me. I cannot say the name of those persons, as they were not known to me. The kitchen room of the temple, situates at a distance of about 15 to 20 feet away from the main temple. Besides me, one or two other devotees were present at the time of occurrence. I cannot say if the deceased was Pujak or Sebayat, but he was worshipping Lord Trivandeshwar during his turn. The deceased was Brahmin by caste. So also the accused Subhash Chandra Muni, Kaliya Muni, and 2 to 3 others, Pujaka, were present at the time of occurrence. While I entered temple from the south entrance, I saw Kaliya Muni was coming from the north entrance of the temple. At that time, Subhash Chandra Muni was inside the Garbhagruha.
ये जो ऊपर ना गुड़ा कहला सुभाष चंद्र मुनि कालिया मुनि एमाने प्रेजेंट थिले along with 2 to 3 others सेमानो भीतर की एग्जाम नहीं चंदी की सुभाष मुनि ला PW3
कालिया ला इन्फॉर्मेंट
माने
इन्फॉर्मेंट PW6
आया अच्छा ठीक है yes next
Lord Trivandeshwar faces towards east. There are 2 gates in the main temple, one the southern and another as on the western side. Subhash Chandra Muni is the own brother of
what is the necessity of putting this question? The जो Subhash Chandra Muni और Kaliya Muni, he has not stated about their presence in the chief examination.
ना
हला जेतबेले क्रॉस एग्जामिनेशन से कहला जे मु कहि परिबिनी 2-3 जण से कंपाउंड भीतर थिले आउ सेमान मु कहि परिबिनी सेमाने किए हला खाली जस्ट पचारिवार थिला जे तमे से सुभाष मुनि आउ कालिया आकु चिन्हिच दैट मच सीट रही जाई थांती ताहले सेमान को चिन्हिची in spite of that he is not telling about the presence. You are bringing out what was not there in the chief examination. You are bringing their presence which should corroborate the evidence of. So this is the art of cross examination. All right, carry on.
I cannot say from which side the accused came to the spot, as I was in your attitude and spot is on a higher attitude. lower attitude and the spot is on higher attitude. At the time of occurrence, the deceased was wearing a cotton towel. The deceased was standing facing towards east at the time of occurrence. The accused was standing facing towards west. I saw accused inflicting knife blow on the left upper arm of the deceased, and prior to that, he had already inflicted other 3 blows, which I had not seen.
अरे okay, ठीक है.
10 to 15 persons gathered there at the time of my arrival. I cannot say the name of the accused persons. I have seen bloodstains on the towel on the floor of the temple. Then, when I saw the deceased, he was pressing his wound by towel. The entire incident occurred approximately within 10 to 15 minutes. Kalia Muni, myself, and 2 to 3 other persons shifted the injury to Aska Hospital. At that time, he was in subconscious state. I cannot say the number of auto rickshaw or the name of the driver of the auto rickshaw which by which we shifted the deceased Prakash to hospital. The Aska police station comes in the way to hospital from Trivandrum temple. We arrived Aska hospital at about 10 to 10:30 a.m. After first aid treatment, Dr. Kaur advised to shift the deceased to MKCG Medical College Hospital, Barampur. I did not accompany Prakash Muni to MKCG Hospital, Barampur. I stayed back to arrange money for the treatment of Prakash Muni. I did not ask anybody about the region of quarrel and assault. I instruct Kalia Muni to lodge FIR. I reached at MKCG Medical College Hospital, Barampur at about 5 p.m. in the afternoon. I did not talk the deceased Prakash as he was in serious. Till 3/9/2002, I stayed at Barampur. I had not asked about the region of assault to Prakash between 28 8 2002 to 2000. After the incidents for the first time, I met Aska police on 3/9/2002. But I cannot say the date of examination by Aska police. It may be after a week or fortnight. It is not a fact that I have stated to police that deceased Prakash Muni is my cousin brother. It is not a fact that I had not stated to police that before entering into the temple, I went to wash my feet in river Ruchikalya, and that while I was washing my feet, hard exchange of words between accused and deceased, and that while ascending staircase, I saw accused stabbing the deceased Prakash Muni, and that the accused fled away towards Jagannath temple. Deceased Prakash Muni was my friend. It is not a fact that I have assisted the family members of the deceased in taking back the surety money from the court of JMFC.
ପଚରାଇଛି କଣ ପ୍ରକୃତରେ କହି ନଥିଲା ନା ଏଗୁଡା ଖାଲି ପଚାରି ଦେଇଛନ୍ତି 161
police କହିନି
161 he is not an eyewitness.
नहीं police ସେଟା କହିନି ବି ମନା
ଆପଣ ପଚାରିଲେ ନା ଷ୍ଟାବିଂ କଥା କହିନି ଇଏ କହିନି ସେ କହିନି ସୋ ଦେଖିଦବା ଟିକେ ତାପରେ ଆମେ ଯିବା ଆଇଓ 161 ଟା ହେଲେ ମନୋରଞ୍ଜନ ପଣ୍ଡା ମନୋରଞ୍ଜନ ପଣ୍ଡା ବାକ୍ ମାରିକିନି ଦିଅ
higher 54 is correct.
Hmm?
Higher evidence re
ने कौन actually कौन पचार दे चली ना कि बेले माने पब्लिक प्रोसिक्यूटर भी देखी न था दी ये कोर्ट भी अन्य कौन कोर्ट थी वैसे यार रिकॉर्डिंग ही चली जो 100,000 ना धारी रही गई थी आगे सकाल 100 मास का स्थित मुनिसाई पात्रे मंदिर को जाई थी मंदिर भीतर देखिली 100 मुनि को ताने पार्टी तुंदर होउथिले सेटार तो गोटे छुरी द्वारा मोर भाई को मंदिर भीतर बारंबार और कोई जुबना
सब कोई
जरा कौन किन पचारले केमते
SDC
ठीक है रिकॉर्डिंग भी करला this is the role now comes of the public prosecutor immediately he should have opposed आज्ञा 161 ने कहिछि चुपचाप बसी जाउछन्ती रिकॉर्डिंग ही चल जाउछि एटा ने all right so now please come to that doctor's evidence
yes madam
with his PW
8
because the other eyewitnesses may be almost identical
yes there is a hot exchange of words and suddenly he attacked
come to the
page 46 page 46
oh no no blow guda ko सब रहला
blow guda रहला second 47
46 रे so and so no no
46 रे अछि
46
stage 2
to drainage tube stitched by so and so present on the either side of the flank so and so from so and so to right and left side respectively
after
already
fasted
left jaw lower drainage pipe acha stitch wound present in the midline of the abdomen below the so and so extending so and so stitch wound obliquely placed over the right upper abdomen with intact to so and so abdomen ने दीटा इंजुरी अछि 2 नंबर और 3 नंबर
yeah
stitched wound so and so lateral side of the chest रे गोटे
successive blows are there
number 4 so and so injury muscle deep on the left shoulder so and so blow on the left shoulder okay external injury number 4 is a stab wound 3 is also a stab wound
1 and 4 are inside
external injury number so and so including this so and so corresponding injuries are caused by sharp pointed weapon this is died out of the so and so time so and so deceased was if the deceased was undergoing
1 and 2 7 on exploration of the extra injury number 1 and 2
both the injury surgical surgical intervention है किन से 5% लगी सी
એટલે કે 9 રે external injury number 4 was a stab
so just think over it what is your submission जब suppose a type रो आपण repeated blows देइछंती on the vital parts of the body माने abdomen रे दीटा chest रे गोटे तापरे left shoulder रे गोटे ये सब जो इंजुरी गुडा को देइछंती and you see the cross examination ne bahar karikina anichandi there were 9 injury on the person of the deceased both external and internal injury number 4 and 5 and 6 were not stitched other injuries were stitched during treatment 5 and 6 are small cut injuries deceased was undergoing treatment at male surgical hospital so and so what is your submission what is your about challenge to the evidence of this witness which we have read. One.
All are similar in nature. All witnesses.
But you
one-
are for the appellant. So
Yes.
you have to say that whether
And-
this is acceptable or not, any infirmities is there, anything which should from which we can say that no, this witness is not a believable one. So identification not dispute.
No.
ଆଉ ଏଠି ମନ୍ଦିର ଭିତରକୁ ଛୁରା ନେଇକିନି ଯାଇ ପୂଜକ ସାଙ୍ଗରେ କଳି କରି ତାକୁ ରିପିଟେଡ ବ୍ଲୋଜ ଆପଣ ଭାଇଟାଲ ପାର୍ଟ ଅଫ ଦି ବଡି ରେ ଆପଣ ଯୋଉ ମାରିଛନ୍ତି ୟାକୁ how have you demolished the evidence of ଏକ ନମ୍ବର ସାକ୍ଷୀ କଥା କୁହନ୍ତୁ ଅନ୍ୟ କାରଣ ଯଦି law is very clear that even if a solitary evidence it is believable, wasn't clear, we can rely on it, and when it is getting corroboration from the
Other witness.
doctor's evidence, medical evidence.
Doctor ଦେଇନି ଯେ injury ଯୋଉଟା last occasion last 18 item ଯୋଉଟା sufficient to cause death. That was not the evidence, doctor's evidence. So doctor's evidence that sufficient in ordinary course of nature to cause death, and he has died after 4 days. And
You
there
try
is
to find out this only. You
Yes.
say that
yes,
have you gone through the evidence of the other 3 eyewitnesses? Same, almost consistent.
same. There is a host exchange of what? And sort of.
injury वाला hitla भी doctor PW 11 माइलर सेते भी से injury part टा भी also for injury
Conspiracy for injury.
PW 11 even.
Yes.
ये जो प्रथम initial doctor
That is 2
Aska,
steps to
Aska.
incise that.
हाँ ସେ ତ ଦେଖୁଛି ସେଇ ଷ୍ଟାଫ୍ ଗୁଣ ଗୁଡା ଦେଖୁଛି ଏବଂ ଚେଷ୍ଟ ରେ ଦେଖିଛି ଆଉ abdomen portion shoulder ରେ ବି ଦେଖୁଛି so
That corroborates.
that is corroborates. sudden quarrel ଅଛି ବୋଲି ଆପଣ you are right that sudden quarrel ଅଛି ବୋଲି ତାଙ୍କ ସାକ୍ଷୀ ହିଁ କହିଛନ୍ତି but
But there is a preparation.
Preparation ଛୁରୀଟା
There is a preparation.
preparation ଯୋଉ ଛୁରୀଟା କହିଛନ୍ତି PW ସେଲ୍ କହିଛି ନେଇକି ଯାଇଛି ସେଟା କିନ୍ତୁ ସେ ପୋଲିସ ଆଗରେ କହିନଥିଲା ଆଉ ଛୁରୀଟା ବି କେହି କହିନାହାନ୍ତି with ଯାଇଥିଲା କି
ନାଇଁ
ସ୍ପଟ ରୁ ସେଟା କିଛି ଏଭିଡେନ୍ସ ନାହିଁ
ନାଇଁ ନାଇଁ ଗୋଟେ କଳି ହେଲା ଆପଣ ଗୋଟେ ସ୍ପଟ ରୁ କଣ ଗୋଟେ ଉଠେଇକିନି ପିଟି ଦେବେ that's a different matter.
Knife is a different.
ହଁ ଆପଣ ଗୋଟେ ମନ୍ଦିର ଭିତରକୁ ଛୁରୀ ନେଇକି ଯିବେ ଆଉ ପୂଜକକୁ repeated blows on the vital part
ଇଏ ବି
ଦେବେ
ପୂଜକ ଗୋଟେ
ଆଁ?
ଇଏ ବି ପୂଜକ
ଯାହା ବି
ସେ ଯାହା ବି ହଉ ଆପଣ ପୂଜକ ଥାଇପାରନ୍ତି କଣ ବିବାଦ ଥିବ ଆପଣଙ୍କର that's a different matter but ଯାହା evidence ଆସୁଛି there was some hot exchange of word and ସିଏ କହିଲା ଯେ କାହିଁକି ତାର ଆପତ୍ତି ହେଲା ଯେ ମନ୍ଦିର ଭିତରେ କାହିଁ ଖରାପ ଲାଙ୍ଗୁଏଜ ୟୁଜ କରୁଛୁ ଏଇଟା ହଉଛି ତାର ଇଏ ଯୋଉଥିପାଇଁ you took it as an exception and gave these blows on the vital part of the body. Yes. Which you had there is nothing that ଛୁରୀ ସେଠି ମାନେ
ସେଇଟା ଏଭିଡେନ୍ସ
ଥିଲା ଯେ ଉଠେଇ ନେଇକିନି ଆପଣ କଳି ଭିତରେ ଉଠେଇକିନି ନେଇଗଲେ କାରଣ as it appears you had come prepared with that knife.
PW7 କହୁଛି ଛୁରୀ ନେଇକି ଆସିଥିଲା ବୋଲି କିନ୍ତୁ ସେଟା ଡିସବିଲିଭ କରିଦେଇଛି
PW7
ଏଟା ପୋଲିସ ଆଗରେ କହିନି ଯେ
ନାଇଁ ନାଇଁ PW7 evidence ଟା disbelieve ହେଇଯାଇଛି trial court
ନାଇଁ ନାଇଁ ଖାଲି ଛୁରୀ ପାର୍ଟଟା
ଓ ଛୁରୀ part but what about no ଆମେ ସେଇଥିପାଇଁ କହୁଛୁ ଆମେ ତ ଯାଇନୁ ସେଠିକି we are just focusing on the evidence of this PW1 ର evidence ଆପଣ how do you we will discard it ତାପରେ question ହଉଛି ଯେ କଣ ଆପଣଙ୍କର ଯଦି ଇଏ ହେଲା whether it would be 302 or any other offense that's a different matter କିନ୍ତୁ as such the evidence ଯାହା ଦେଇଛନ୍ତି ଏଇ PW1 ବା ଆପଣ ତ ନିଜେ ପଢିଛନ୍ତି जो अन्य तीनटा आई विटनेस,
Almost
so almost
same.
one corroborates the other.
corroborating each other.
Now, if we go to the second part, what is the offense would be, then how do you overcome all these things? That taking the knife inside the temple, and it's all right, there is a quarrel, giving repeated blows. It's not any gote konosi kebalo se shoulder ta heipare, but otherwise all the parts on which you have assaulted, those are all vital parts of the chest out pectory dithar footage. So have you found out any decision on that?
ଆରଟା ରହିଯାଇଥିଲା ଏଇଟାରେ କନେ ଆଉ
That's it.
ଶୁକ୍ରବାର both the cases.
Find out one decision is there in 89 Supreme Court. Hala? 89 Supreme Court achi ki? AIR 89 Supreme.
Surinder Singh.
हाँ.
Surinder Singh, state of Kerala.
89 Supreme Court, that was a case of repeated blows. Hala? Where it has been held that once it is a quarrel, sudden quarrel, then who caused provocation, it is immaterial. Number of blows is also immaterial. It is to be seen by the court whether he acted on the grave and sudden provocation or not. तादरे भी गुड़ाई blows देइथिला और कड़ी हितला से जाइथिला सेठी कोन बारंडा रे सोइथिला ना कोन repeated मगीदला. हाँ. So but merely because there are two things. Suppose you cannot argue that merely because the death got delayed. He was treated in ICU. MKCG, one of the best hospital, tinta best hospital vitere our government hospital, one of the best hospital. So sethi jane ICU re treatment hochi immediately 4 दिन ପରେ death hochi. ତେଣୁ ଆଉ କଣ ତାକୁ ଇଏ କରାଇଥାନ୍ତା, and that is not a ground that merely because better treatment ହେଇଥିଲେ ସେ ବଞ୍ଚି ଯାଇଥାନ୍ତା, that is not a ground to reduce, that is there in the section itself. ତେଣୁ
Let him try out. Let him.
This one that I just killing. I'm of the This man is in custody.
No, yeah, the bail, release on bail. 24 for 13, 2013.
No, କେବେଠୁ ଦେଖିଛନ୍ତି LCR verify କରିଛନ୍ତି କେବେ custody ରେ ଗଲା, trial court ରେ bail ରେ ଥିଲା କି ନାହିଁ?
bail ରେ
ନଥିଲା. What is the date of initial date? ଏଇଟା ବାହାର କର, final form ଟା ବାହାର
arrest ହେଇଛି. On this
LCR ଟା ବାହାର କର.
29/8/2002 arrested and same day he is forward.
Wait. Final form. Okay, the date is 29/8/2002. And he was not on bail during trial.
No.
Huh?
No.
Produced in custody, right. Ethi appeal le kebe bail le gala?
24/4/2013.
Huh?
24/4/2013.
So 10 years 9 10 11 12 1 2 3 4 हेले 8 मास
10 years 8 months.
कौन हला हाँ 89 रो तो दीटा पार्ट अछि AR 89 नो कौन हला why are you sitting here ask that librarian to come. The number of rounds caused during the offense is not a decisive factor. What is important that the offense must have been an external and unpremeditated. The offender must have acted in feet of harm. Judge must not have taken away undue advantage or acted in cruel manner. When a stubborn trial is filed, the keeper picks up his weapon, which was in handy, and pledges in one of his close battle many could have seen. Thus, very also decision regarding possession of this sanction. It is a number of injuries still. Just one of the we want to take the help of this decision. So, it is actually has now with the purpose to see that it is difference. You take down this decision and go to it.
Yes,
That is AR 89 Supreme Court. Page is 1094. And party name is Surinder Kumar versus Union Territory. This decision has been relied upon by a number of decision of our court. Okay, wherein it is discussed that how suppose you have acted in a fit of anger and also assaulted on the vital part of the body, but the background is this gen and city con hoba. And also try to find out if you can get, you are raising a point that 4 days pass kola suppose. But treatment has been provided in the best hospital. Sethi aapnu kisi relief milibo. We'll take up this matter tomorrow.
Friday, other matter is other matter is there 18 Friday.
Friday पर आपनको same matter टा रही ना
दीटा जगह रहता
और सही दिन रखियो पूजन
से दिन कर परिए ठीक है
रखियो Friday रखियो
My lord, if I don't mention on item 294, but that weekly list, my lord. There's been delay of 152 days, my lord.
For what?
Criminal appeal, filing appeal, my lord, criminal appeal.
Marco.
294, my lord.
Huh? Hey. What is the conviction and what is the sentence?
20 years, my lord, the conviction. 20 years. 20 years and pay fine. Pay 33, my lord.
And what is the delay?
Delay, my lord, 153 days. As per my calculation.
149. Yes, Mr. Tripathi.
Yes.
IA number so and so. This is an application for condonation of delay. Considering the stamp reporter has pointed out that there is delay of so and so days in filing the criminal appeal, 149 days. For hearing the land counsel for the appellant land counsel for the state and going through the averments taken in the interim application, since it's a case of conviction in which 20 years substantive sentence has been imposed. I'm inclined to condone the delay. According to delay is condoned, IA disposed of. I'd admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Yes.
Same page, 95. Condonation for delay, man. Conviction of 20 years, man.
Which one? 295.
539.
$479. Sentence is
20 years.
operative part.
28, man. 25, 28, judgment period 18.
All right, same order, but only that days taku change kar debe, है ना? So delay condone, admit, and interim applications for bail and stay shall be considered after receipt. Yes, next.
ये pardon me, my lord. Weekly list 230, my lord. Kindly taken up today because I already for interim bail for instruction ପାଇଁ
देखो कौन instruction आस्ची कि नहीं.
Pardon to me, one CRLA number 95 of 2015, my lord. The person is more than 10 years in the custody. The sentence imposed upon him is already undergone. And for the default of fine, he is languishing in jail custody.
Pardon, sir, IA has been filed for anything out of for judgment, stay of judgment and order of conviction. CR
Give it, it will come. जी.
Regarding cheat funds, 8 years he is in the custody.
एक कौन होची देखो तो list करो.
I file for stay realization of fine, madam.
Diyan.
may pardon mention item 293 conviction there is
293 वर्क. What is the delay, Mr. Panda?
365 days delay. Conviction page 28. RI for 5 years. And under section 326, page 28 of the judgment.
372 days delay. Page 20.
Page 28 of the trial court judgment, madam.
Okay. Okay, it's 5 years.
My lord.
And you were on bail during trial? Yes?
My lord.
Okay. How many appellants are there? Madan Naik only.
Madan Naik only, my lord.
Madan Naik has been released on bail.
My lord. No, during trial he was on bail and he has served sentence 1 year, 6 months, 9 days. Page 2 of the trial court judgment.
All right. Yes, Mr. Tripathi.
After conviction, he is in jail.
So delay condone and had admit call for the trial court record interim application for bail. Out of 5 years substantive sentence, he has already undergone 1 year and 6 months and 9 days as per the accused details furnished in the impugned judgment. So bail allowed, stay realization of fine.
May pardon, delay.
Delay condone, admit, bail allowed, stay realization of fine.
And another prayer, my lord, notice will go in 103.
Just a minute. Yes, 100.
103, my lord. Notice will go to OP number 2, SC/ST Act, my lord.
First time it's listed.
Yes, my first time. Notice will go and serve extra for
103 extra copy to be served by tomorrow. Notice CDCA and written report on the sufficiency of service of notice. This is item number 100.
103.
All right. Yeah.
$176.
What do you want?
The report instructions were sought for.
All right. देखो तो आशी ना नहीं आधे report. We'll see.
Published.
88 and
92.
these are all SC/ST matter. Press matter.
Yes.
Mr. Das, 88 and 92 are SC/ST bail. So extra copy will serve and notice to be issued and CD and CA is to be all right.
Pardon to mention, my lord.
Huh?
114 losses. So what is the already has been released on bail losses. Kindly second
When the matter reaches, we'll see.
Pardon to mention, my lord. CRLA 637/2023. I want to withdraw the matter.
CRLA.
My lord.
It list कर दियो खाली withdraw पाई.
My lord, item 83, 84. Yes, matter, my lord. Appeal for bail. Notice to
SC/ST matter.
my lord.
All right. 83, 84. Mr.
83,
Da.
84.
Das. 83, 84. So extra copy to be served by tomorrow. CDCA.
Pardon to mention, my lord.
Yes.
Item 263. Can be taken up today, my lord?
Why?
That there is, my lord, the basically source testimony of the victim. He has been convicted. He was on bail during trial, and the statement is not clear, question, and it's a trustworthy.
When the matter reaches, we will see that. Yes. Next.
Item 268, my lord. The petition is already served 7 years out of 10 years.
All right. When the matter reaches, yes. Call the matter.
118, my lord.
118
weekly list, my lord. ଥିଲା ସିରୁଟିର ବାପା ମରିଛନ୍ତି ନା ମରିନାହାନ୍ତି ସେଇଥିପାଇଁ ଥିଲା ଆଉ 10 ରୁ 8 ବର୍ଷର ପାଖାପାଖି ରହିଗଲାଣି
ଫାଇଲଟା ଦେଖନ୍ତୁ କଣ ହେଇଛି 118
ସିରୁଟିର ସେ ଦେଇଥିଲେ ବେଲବଣ୍ଡ ଦେଇଥିଲେ କିନ୍ତୁ ସିରୁଟିର ବାପା ଅଛନ୍ତି ମରିଛନ୍ତି ନା ମରିନାହାନ୍ତି ସେଇଥିପାଇଁ ରହିଥିଲା
all the matters.
Supplementary list item number 1.
Bail under SC/ST. It has to go.
All right, extra copy to be served, notice to issue. CDCA and also written instruction about service of notice. Yes.
Two also set.
Two also same. Yes.
Item number 2.
Yes.
Item 3.
Wait, please, my lord. My lord, herein the appellant is the lady who has been convicted and sentenced to undergo 3 years under section 7 and 4 years under section 13(1)(b) and 13(2) of the Prevention of Corruption
The
Act.
operative part of the judgment.
My lord, the operative part of the judgment is at page 79, internal page 61.
Okay, so it's 4-year sentence. You are on bail during trial.
Yes, my lord.
And now you are on bail or in?
Now I'm surrendered before the learned court.
Why you are not granted bail by the trial court?
My lord,
After conviction?
I have moved before, my lord.
No, after conviction, whether there is any power with the trial court to grant bail to the accused. Is there any provision?
3 years.
Is there any provision in the CRPC that trial court after convicting has the power to release the accused on bail? And if so, under what circumstances? And in this case, why you are not granted bail? Read 389. Okay. If it is 3 years, he has power to grant bail. Okay. If it is 4 years, so obviously he has been taken into judicial custody. All right. All right. Yes, Mr. Das.
My appearance by the end of November, and also the IA for stay of conviction by the end of November. I will file my objection.
All right. Admit A. Mehta. Bail allowed. Stay realization of fine. And so far as stay of conviction is concerned, Mr. Das submit that he will file the appearance memo by end of November. Name of Mr. Das be reflected. Free copy be handed over to the Land Council for the Vigilance Department. Yes.
Obliged.
Item number 4.
May Lordship, the petitioner being a lady convicted for the offence under section 21B of NDPX Act for 3 years, that is Miller operating party, Pat Miller, running pay 38 Miller. 38 Miller. Second paragraph. Hence, the convict is directed to undergo RI for 3 years and to pay fines so and so.
You were on bail during trial?
No, during trial I am not in bail, Miller. After conviction, Miller, 383.
Okay. Yes, Mr. Da.
5 ମାସ ରହିଥିଲି ସେଟା ଆକ୍ଟିଭ ଡିଟେଲ୍ସ ରେ ଅଛି ବେଲ୍ ଆପ୍ଲାଏ
For the trial court record, he was not on bail during trial, and as such, he has already undergone substantive sentence of 5 months out of 3 years. Bail allowed, stay realization of fine. Yes.
Beller list, my lord. Last time it was submitted that the genuineness of the mother of the illness of the petitioner is genuine and the address is correct. I have furnished the copy of the Beller's list of Bellers.
He's from West Midnapur.
West Medinapur on the ground of murder.
So have you supplied it?
Yes, my lord. On
What is your instruction?
My lord, genuine.
Genuine. Address is correct.
My lord.
And this report about this element is also
ଗଲା ଡେଟ୍ରେ ଆଗରୁ ତ ଥିଲା ଅର୍ଡର କରିଥିଲେ ଗଲା ଡେଟ୍ ଏଲମେଣ୍ଟ ଇଜ କରେକ୍ଟ ଅଛି
IA number 1991 of 23. It's an application for interim bail on the ground of ailment of the mother of the petitioner. Medical documents have been annexed to the interim application. Land Council for the state has obtained instruction from the inspector in charge of excise, EI and EB unit to Cuttack, from which it appears that the medical prescription of the mother of the petitioner is genuine. And there is kidney stone problem. Land Council for the state has also verified that the address of the petitioner as furnished in the cost title is correct. And so also the two local securities documents which are furnished are also authentic. Considering the submission made by the Land Council for the respective parties, the amendments taken in the interim application, the medical document annexed thereto, the instruction obtained by the Land Council for the state, I am inclined to release the petitioner on interim bail for 1 month. IA disposed of. Fix a date for filing surrender certificate.
and I may pardon
Yes.
you're about 4 years in custody, some more days 8
Okay.
weeks
Make it 15 days.
Yes.
Yeah.
Item number 8.
4 weeks or 6 weeks
15 days.
no, 1 month I may pardon 1 month
All right. Yes, next.
An appeal under section 14 of SC Act.
5D, you have supplied the D.
Requisition copy I have yesterday served on the government council.
What is the sentence imposed, sir?
No, my lord, it is a section 14 SC Act.
Notice has been issued.
Notice issued, my learned senior is appearing.
Okay. RI for 5 years. 5,000, that is for 376 by 511.
Item 8.
302.
CRLA number 1116 to?
Yes,
Again.
ma'am.
So Bharti 376. It upload ହେଇଛି 1116 of 2023. File ଅଛି list ହେଇଛି 1116
22.
କରୁଛ ମାନେ ଫାଇଲ ଦେଖିଲେ କଣ ଆସିଛି ସ୍କାନିଂ କରିଛନ୍ତି 1116 of 2023 ର ହଁ 23 ର ଆସିଛି 22 ର ଦିଅ Is it your first bail application?
In fact, last occasion your lordship's query was.
Just a minute. You submitted that 11 witnesses.
15 examined.
15. What is the date of custody?
Date of custody is the 17/6/21.
Charge sheet under section? Charge sheet under section 302, 394. Yes. 323, 326. 320? 324. 394 पर 324. Okay. 326 Miller. 307, 506. And 31 are of SCST Act. So eyewitnesses are there.
Yes, yes.
Injured.
Several.
Injured eyewitness. Injured is there. So who is that injured? Injured is Babula Miller. Babula.
Babula Malik.
Babula Malik. And who is the deceased? Deceased is Ramesh Malik, his brother. 15/6/21 is the date of occurrence, Miller. 15/6/21, 2021. And charge sheet was submitted on 21/10/21. So now, what evidence has come against you? They have stated that I have assaulted. Which witness? Miller,
PW1, 3.
1, 2 also says.
3 of the injured eyewitness, Babula Malik.
Let us see PW3. Miller. Accused Katia. Again. This man, okay. Committed theft of banana fruit from our yard. My father and elder brother, after alighting from the roof, disclosed before us. So and so on. To have a discussion with the gentries of the village. Thereafter, myself and my elder brother went to village Beno Gadia of our motorcycle. There in front of the house, so and so caught hold of the accused. Immediately, Katia immediately assaulted my elder brother with a knife on the head, neck, ribs. Receiving assault, my elder brother died at the spot. So, number of blows seems to have been given. Miller, it seems to be a case of exceeding right of private defense. That is to be adjudicated by the trial court. Now, Miller, what are your grounds for bail, except that you have detained in custody for about 2 years and 3 months? Miller. And out of 30 charge-sheeted witnesses, 15 have been examined. Yes, Mr. Tripathi.
Yes, Miller.
And what about the criminal antecedent? 2019. Offense under section
41, 324, 326, 307.
307. Way back in 2019. Way back on এটা কেবে কারগি? এটা 21.
There are many other omnipotent crimes due to terrorism of people.
1999 ପରେ ତ କୋଭିଡ ଆସିଲା, ଘରେ ଥିବେ, 22 ରେ ବାହାରିଲେ ତାପରେ ପୁଣି କ୍ରାଇମ କଲେ ହବ? ନା ଏଇଟା 21 ରେ 22 ନା 21? ହଁ 21 ରେ. Are the Land Council for the Appellant Land Council for the State Land Council for the informant submitted that appellant is in judicial custody since 17/6/21. 15 witnesses have already been examined in the trial court, and charge sheet has been submitted under section so and so offense should and at this stage there is no chance of absconding or tampering with the evidence. Therefore, the bail application may be favorably considered. Land Council for the state oppose the prayer for bail and place the evidence of PW3 Babula Naik, who is an injured eyewitness. The Land Council for the informant also opposed the prayer for bail and submitted that there is one criminal antecedent against the petitioner, that too under section 307 of the Indian Penal Code. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced by the prosecution so far, while not inclining to release the petitioner on bail on merit but taking into account the period of detention in judicial custody, I am inclined to grant him interim bail for a period of 3 months while on interim bail shall appear before the learned and trial court on each date and shall not try to tamper with the evidence disposed of. Yes, obliged.
Item number 9.
My lord, 3rd October 2023, my lord, in IA number 2316, my lord. While passing order, my lord, it has been observed, relevant person is that, my lord, the learned counsel for the petitioner submitted that the petitioner was on bail during trial. And after interim order of conviction and sentence was passed, he was also on bail, my lord.
Huh?
That part can be modified, my lord, because on the
Which part you want modification?
my lord, the third para of order, my lord, and the last para, my lord.
You are not on bail during trial.
I'm in bail, my lord, but on the date of judgment, my lord, soon after the pronouncement of judgment, he was taken to judicial custody, my lord. And in the last para, my lord, let the appellant petitioner be released on surrendering before the learned trial court. That may kindly modify.
All right. IA number 2433 of 23. This is an application for modification of the order dated 3/10/2023 passed in IA number 2316 of 2023. The Land Council for the petitioner submitted that inadvertently it is mentioned in paragraph 4 of the order number 2 dated 3/10/2023 that after the impugned order of conviction and the sentence was passed, the appellant was on bail and therefore he was asked to surrender before the London trial court in the operative part of the judgment. But in fact, after the impugned judgment and order of conviction, the appellant was taken into judicial custody and therefore the order may accordingly be modified. Land Council for the state has no vigilance department has no objection in paragraph number 4 of the order number 2 dated so and so in place of after the impugned order of conviction and sentence was passed, he is also on bail, inverted comma vitarka. The same shall be read as after the impugned judgment and order of conviction and the sentence was passed, he was taken into judicial custody. Similarly, in the operative part of the judgment, the words on surrendering shall be deleted. The rest part of the order dated so and so stands unaltered. IA is disposed of. Yeah, I'll
Free copy of the
free copy of them.
Item 11.
May please.
Item 64, Lordship, taken up after vacation, Lordship.
After
Extra copy not filed, my lord. File for.
let a land counsel for the state submit that in spite of the order dated so and so, extra copy of the appeal memo has not been served on him. Let the land counsel for the appellant serve
Lordship,
copy of the delay.
Oh, this is the acknowledgement.
Acknowledgement Haji out of the
They
yes, extra copy be served, matter to be listed after ensuing puja holidays.
Item number Item number 69.
69, my lordship. Last copy, the lordship dictated to me the file extra copy. I have sought the extra copy also.
What about notice, Mr. Tripathi?
No extra copy is not there.
You say that he has some
Proceed, lordship.
land counsel for the state submits that he has not received the extra copy of the appeal memo. However, the land counsel for the appellant dispute the same and submits that he has already served the extra copy in the AG office. Be that as it may, as another copy to be handed over to the land counsel for the state by tomorrow. Okay.
Tomorrow, lordship.
Notice to be issued after Puja holidays.
Item number 70.
Item 76.
instruction informant is not available. Informant upare copy serve hei parla nahi. ଆଉ ଥରେ try କରିବ mail adult male member of family. ଆଜ୍ଞା ଆଜ୍ଞା ଆଜ୍ଞା
Item number 77.
May I pray, Lord? The case of my Lord CICL, my Lord, the juvenile against the order of children's court.
77 ଟା
Stamp report it is ଲେଖା ହେଇଛି my Lord. Yes, my Lord. Yes, I have already filed, my Lord. My Lord, IA number 441 by 23, my Lord. Yes,
हम copy ଦେଇନାହାନ୍ତି
I have yes, already solved.
copy ଟା ଗୋଟେ ଦିଅନ୍ତୁ
Yes. My Lord, here, my Lord, the 21201, my Lord, appeal, my Lord. Subsection 5 it says, if the order of the children's court is there, so you can file appeal before the High Court. Yes. Yes, sir.
Yes.
No, my Lord, that is the juvenile children's court, my Lord. Additional session judge come juvenile court. Yes, my Lord. Yes. Yes. Yes, ma'am. Yes, madam.
So revision habo another appeal second appeal
Yes.
करके
We have already filed.
Item number 78.
Item 78, may I please, Your Lordship. Lordship, in this case, the appellant is in custody since 15/12/2018 for the offences punishable under section 147, 148, 325, 506, 307, 302.
notice ଯିବ ଯିବ
Lords, already served, Your Lordship.
already served
Yes. Undated 24/8. Lordship, earlier application has been withdrawn.
notice was not served through us
Yes, I have served the extra copy on dated 24/8/2023.
ଆଜ୍ଞା ଆମ ପାଖେ ଆଜି ପ୍ରଥମେ ଆସିଛି ତ ମାନେ ଆମ ରେକର୍ଡ ଦେଖୁଛି
Yes, sir. Ye-
No, then, my lord, maybe inadvertently, ଆମର ଆଜି ପ୍ରଥମେ first ଦେଖଉଛି ଆଜି କିଛି order ହେଇନି।
Yes,
କାଲି
your lordship.
ନେଇଯିବି order ଟା ମୁଁ। କିନ୍ତୁ ଆମର ପାଖେ କିଛି confirmation report ଆସିନି ଆମ ପାଖକୁ।
Please do. Yes, sir.
Item number 79.
May it please, my lord. Your lordship is not audible, my lord. I'm so sorry.
What is defect
Lordship.
number 9 is good ground certificate not furnished. Okay.
Lordship.
So
The confirmation report ଆସିଛି, notice has been served
କେବେ?
on 1/10/2023 7/10
7/10
ଆଜ୍ଞା
7/10 ହେଲେ ଆପଣ ଅପେକ୍ଷା କରନ୍ତୁ।
7/10
ଗୋଟେ ସପ୍ତାହ ହେଇନି ସେ engage. It will come on 16, Mr. Das.
Lordship.
The
As
notice has
lordship.
been served on 7/7. The
Lordship.
Guardian Council for the state submitted the notice on the informant has been made sufficient on 7/7/2023. However, she has received the case diary. List this matter on 16th October 2023. If any Guardian Council has entered appearance for the informant in the meantime, his name shall be reflected in the cause list. Yes.
Grateful, my lord. Both the cases, my lord, there is a tagged case which is CRLA
Okay.
76.
This will come along with the second one. With
Again. Grateful, madam.
Item number 80.
Ramdas Acharya.
So the thesis is there.
Notice sufficient.
81 82 ଟା ଯେ
ଦେଇନାହାନ୍ତି କପି ଦେଇନାହାନ୍ତି
ନାଇଁ
ନା
first time ଆସିଛି
first time ଆସିଛି।
extra copy to be served during course of this week. Usual order CD CA written instruction and after Puja holidays. Yes, next.
Number 83.
वाला पर 83 84 जाई छै
Item number 85.
I may be permitted to appear through
yes
virtual.
yes sir.
The charges submitted under section 417,
wait
493.
नहीं हमर आसीनी instruction my lord copy sir notice जाइछि आसी
notice जाई छी
आगे
and CDB आसीनी
ना किछि
all right land council लिखि देबे जे it has not been received about the service of notice so after puja holidays CD CA and information about sufficiency of service.
Oh, bless me.
Yeah.
आगे
ताले थाओ आरो सप्ताह देखियो so 810 is the service date of notice to be listed on 16 10 20 and you have received the case diary
आगे
oh.
Item number 89.
वाला पर 89 जाई छी no no 89 जाई छी 16 10 23 को रखा है लिखी हां अच्छा हो 89 डा कतन
Item number 89.
Item 87, I am appearing for the informant.
all right file then
And a copy I have not received.
where is that Mr. Das Naik Naik hand over a copy is not lekhondu Mr. Swanso seta kati dion se order ta Swanso files the wakalatnama which is taken on record. He submits that he has not received the copy of the appeal memo. Copy of the appeal memo be served. तानो phone number नहीं जाऊँ ना copy serve कर दे. Matter to be listed on 16th October 2023. Yes.
supplementary list रे आसले ठीक
नहीं नहीं सही तरह आसियो नहीं आबो. Yes next. एटा ये जो 88 टा रहिला अब एटा 89 टा मुकेम लिख देली 16 10 बेले. हाँ हाँ 89 डकाइनी डाकुनो
Item number 89.
you have received the case diary
नहीं ना आगे
एटा कौन conviction होते
आगे
CR
374 किंतु एक्सिस्टी एक्ट तो अच्छी नहीं
हाँ एटा conviction case टा
आगे
7 years conviction is there. ये 16 10 को रखी दी था देखियो और लिखी दीजिए नोटिस इधर जाई नहीं
ना
सर लिख दिया conviction 3SC स्टेट रही जी तो
आगे TSS एक्ट एक्चुअली किंतु एक्शन करना है नहीं एक्यूटल ही जे चंदा दे सिस्टम
ना 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 so no notice is necessary
No,
so such as
खाली 307
16 10 रे रखी दिया है ना next
Item 90.
90 में lordship
Here, let's say, is a case where the petitioner is an informant in an FIR where SC is there. And when she applied for the certified copy of the other documents, he was denied. And then impugned order is at page 13, let's see. She is denied on the ground that she is not in party to the proceeding. Page 13, the impugned order. May read, let's see. Therefore, this court concludes the victim, bracket copy application, is not entitled to certified copies of document as required by him under copy application number so and so. As such, said copy application stands disposed of as rejected. For the appearance of the accused person, issue fresh summons. No reasons is mentioned. And at page 17, on page 17, let's see that the petitioner is the informant.
17.
Page, on page 17, 17.
What documents you sought for?
Lordship, the copy application, Lordship, at page 11, turning page 11, there, Lordship, kindly see.
Just a minute.
Lordship.
Ah.
Page 11, that is the copy application.
FIR charge sheet, so on, so on.
Lordship, Lordship. She was denied. And thereafter, again, again, Lordship, at page 14, and the copy application filed to get the an entire order sheet of that decision order, that was also denied. Page 15 is the answer. The copy application may kindly be rejected as per the report of the dealing assistant.
The victim informant किसी document मागुची FIR charge sheet रो ताकू मना कर दिले certified copy दवा पाए trial court. Yes, she has a right to go through the same.
Yes, sir.
But that has been rejected on the ground that she has कौन observation कौन अछि?
Observation I तो clear करू नाहंदी खाली लिखिसन देती कि जे page 13 Lordship. Therefore, this court concludes that the victim bracket copy applicant is not entitled to certified copies of the documents as required by him under copy application number so and so. As such, said copy application stands disposed of as rejected. No reason is mentioned. That is the extract order.
The appellant is the informant in Sindhikala PS case number 71 dated 14/4/2022. In which was registered under section 341, 323, 294, 354, 353, 332, reduced section 34 of the Indian Penal Code, 31R bracket S and 32BA of the SC/ST POA Act. Against 14 accused persons. It is stated at the bar that on completion of investigation, charge sheet has already been submitted. The petitioner applied for the certified copy of the FIR, charge sheet, 161 statements, medical report, seizure list, notice under section 41A and 41B in connection with special GR case number 20 of 2022. However, the London trial court, that is the additional session judge cum special judge Titlagar, rejected the copy application as per order dated 8/8/2023 on the ground that the appellant is not entitled to the certified copies of the documents as required by or him कौन कर दीजिए?
हाँ sir, there is no extra. It's just extra order. No reason is mentioned. Then next application is made on page 14. For that reason, next application is made. That is page 14. There also that was rejected. I mean page 14 अच्छी.
By him कौन लिखला?
हाँ sir, लिखी चंदे भूल है हाँ लिखा था
as per the copy application.
no reason is mentioned.
Another application seems to have been made on সেটা কেবে করলে?
This was 7-8-2023 है
हाँ
Annex 3 page 14 है rejected in view of the rule 254 GRC. That is the reason mentioned there, the top of the page.
Another application was made for obtaining the certified copy of the order of rejection of the copy application and order sheets. In the said case, Chitrakonala,
that was again denied.
Which was also rejected.
The reason mentioned at the top, page 14, the top right side mention करचुन reason था. In view of rule 254 of GRCO criminal volume 1.
In view of rule 254 GRCO volume 1, as the applicant is not a party in the case.
But 254 reads that I have quoted in my petition, so also the book is there, Lordship.
The learned counsel for the petitioner appellant submitted that a GRCO criminal volume 1 achi that 254 of the GRCO criminal volume 1 reads as follows. Quote it, is party to the criminal proceeding may at any stage before or after the disposal of the case obtain copies of the records of the case or proceeding, including exhibits which have been put in and finally accepted by the court as evidence. SCST Act दिया. The 1989 Act was enacted to prevent commission of offense of atrocities against the member of scheduled caste and scheduled tribe, and to provide for special courts and exclusive special courts for the trial of such offenses and for the relief and rehabilitation of the victims of such offenses and for the matters connected therewith or incidental thereto.
In my petition, Lordship, paragraph 5, I also mentioned some provisions, Lordship.
Section 15A of the Act, which is there in Chapter 4A, deals with rights of the victims and witnesses. In subsection 5, it is stated that a victim or his dependent shall be entitled to be heard at any proceeding under the Act in respect of bail, discharge, release, parole, conviction, or sentence of an accused, or any connected proceeding or arguments, and file written submission on conviction, acquittal, on sentencing. Once the victim has lost the first information report and charge sheet has already been submitted on the FIR of the victim, it prima facie appears that the victim's case has been found to be correct, prima facie found to be correct, and accordingly, when he has got the right, as already mentioned in subsection 5 of section 15A of the Act, unless he is supplied with the complete police paper, if applied for, it would be difficult on her part either to assist the public prosecutor or special public prosecutor, or to bring relevant documents on record during course of the trial, which will be prejudicial to his interest. If she engages any counsel without those documents, it would be difficult for her counsel also to prepare the case. In view of the subsection 5 of section 15A of the SC/ST Act, which is quoted above, I am of the humble view that the London trial court was not justified in rejecting the application filed by the petitioner, filed by the appellant. Accordingly, the impugned order is set aside. However, it is directed that if within a week from today, the appellant files a fresh application asking for the copies she requires, the same shall be supplied to her immediately. Copy of the order be communicated to the London trial court for compliance. Yeah,
Grateful.
it's allowed.
Grateful.
Item number 91. Item number 98.
This is the first time listed and three ACCR to my lord.
Bail matter.
My lord.
Copy not served.
Copy served and extra copy be served.
No, you served 2 copies. It is not there available. Another sub copy.
My lord. In course of
two-
the day.
Okay, 2 copies be served on the Land and State Council. One is to be retained, the other has to go to the informant. CDCA and other details. Yes, next.
Item number 99.
Beg pardon, my lord.
Item number 100.
100 আমার কপি সার্ভে দিয়েছে আজ্ঞা 2-10 রু
Custody. What is the offense here?
36 and 294. 86, 3 assist.
294 and 3S.
ଘର ପୋଡିଦେଲେ
ତାଙ୍କର ଆଲିଗେସନ ହଉଛି attended call of nature ବିଡି ଟାଣିଲେ ସେ ଦିଆସିଲି କାର୍ଡଟା
ଦୋକାନକୁ ନିଆଁ ଲଗେଇଦେଲେ କେବେଠୁ ରହିଲେଣି
5/6/2023
ଆପଣ କାହା ପାଇଁ କଣ କହୁଛନ୍ତି?
The whole contents of the petitioner is that he has unintentionally set fire on the alleged room, my lord. But in the rejection order, it reflects that 3 eyewitnesses are seen when he set fire, my lord. And he is having number of antecedent, my lord.
One antecedent that took
What is the antecedent, Mr. Mrs.
ନାଇଁ ଆସିନି କିଛି
one antecedent political ଏ ଯୋଉ ଘେરો ଫେરો ହେଇଥିଲା ସେ that was the antecedent and he is in
As per
Have you got the details of those antecedents? He says only one. If
Only
you are
one.
opposing the bail application, you are supposed to provide the court what are the cases.
yes, my lord. Adjourn to next week, I will provide all that.
All right, 16th it will be taken up. No further adjournment. You may, Mrs. Patnaik,
ଆଜ୍ଞା
you also take instruction. The Land and Council for the informant submits. ଆପଣ power file करना
My lord, 510. I already filed.
What is your good name?
S.R. Panda.
Mr. S.R. Panda Land Council submits that he has already filed power on 5/10/2023. Let the registry place the Wakalatnama on record. Name of Mr. Panda be reflected in the cause list and score. During course of argument, the Land and Council for the informant submitted that he has got instruction that the appellant has got number of criminal antecedents and the matter may be taken up next week in order to provide the case details. Land Council for the state submit that she has received the case diary, but instruction regarding
কেস দেবে
Asini?
না
Okay, she has not received the case diary. So list this matter on 1610 CD CA to be obtained in the meantime. Yes.
Can I submit one thing, my lord?
dashboard
If they're saying one antecedent, then they may file comprehensive affidavit.
ଆରେ ଆପଣ ଦିଅନ୍ତୁ
ଆପଣଙ୍କ କଥା ନିଜେ ବୁଝନ୍ତୁ ଆପଣ ଦେଇ ବେଲ ଗଲା କାମ ସେଣ୍ଡିଓ. Yes, next. Call the matter 545.
Item number 101.
And password नहीं है.
पर इससे 4-5टा अच्छी सर जाओ. 101.
101, may I please, your lords?
Fresh matter.
Fresh matter, but informant has already appeared. I have already served the copy.
You have received the case diary, Mr.
Depositions have
नहीं.
supplied the deposition.
All right.
File आसिन ना
Next.
100 पर file आसिन.
वो आसिन गया अच्छा. All right, then all these matters will come next week. जोड़ा को 500 हो रही गला, जोड़ा को ऊपर को. एगुड़ा नोटिस ही चिना नहीं. हाँ 102 102 रे नोटिस कर दियंतु 104 टा मिस्टर तारा प्रसाद महापात्र फ्रेश मैट पड़ गले एटा देखि देबे जदी फ्रेश मैटर रही तो नोटिस कर देबे
एसी स्टेट ले करथु
हां एटा गोटे कोन सीआरएल 1084
I please your lordship. Here is the offense under the conviction under 325, my lord. Initially,
just a minute 360 अछि की
my lord, but the serious, my lord, acquittal, but only 325 IPC his conviction.
wait
Lordship could
360 act ru acquittal ye jandi
my lord.
operative part of the judgment
53, page 53. Para 19.
wait
Sorry.
53
Page 50.
Jogendra Vera is sentenced to undergo RI for 3 years.
My lord.
Pay fine of rupees 10,000,
My lord.
325 in default to so and so. All right. So, Mr.
My lord,
item number 105.
My lord.
You are on bail during trial.
My lord.
All right. Admit. Call for the trial court record. He was on bail. Bail allowed stay realization of fine. So, rest of the matter next week we'll take up.
Item number 279, my lord. Only defect a copy already been solved. That point to be
आरो सप्ताह रे कहबे
fresh asle.